This is a game. They want to take me from my wife and everything.
Should be pretty quickly. Okay, but I want to see if we can do this today. This court has a jurisdiction.
This court, if it's going to be part of this case, then we should be able to arraign me right now.
You should be able to. I'm arguing for that. We're not arraigning if you haven't been indicted.
All right.
Let's go on the record in the matter of state of Arizona.
Right, let's go on the record in the matter of state of Arizona versus CR-2025-1060 defense motion to represent itself, defense motion to represent and the status conference, parties
Rachel Stiles for the state. Rachel Stiles for the state.
This is William Parham. Mr. Myers, something came up. We need to address.
Okay, I want to address something else. I want to address something else. First of all, the first thing I'm going to announce is streaming. But then I want to address request of the Joey Payne of the Phoenix Times. To have cameras in the courtroom. I was under the impression when this was from the Phoenix New Times, and that's how I identified it yesterday. Maybe I didn't read it close enough. And then yesterday during the hearing, Mr. Myers had said that he owns this. I looked up the Phoenix Times. There is a website called the Phoenix Times. It basically links to other news articles and posts press releases. I couldn't find any Joey Payne associated with that. And our public affairs representative indicated that the person here today is from RP Media, which is a different company. So I'm not at all certain who's actually making the request. And without that, I'm going to have a hard time to stream this. So Mr. Parvin, I'll start with you first. Your position on this.
Well, my position is, again, we've already ruled because there's no victims, or the court ruled because no victims here, there are less concerns. There's no objection to streaming. I think the court already prohibited Mr. Myers from using his own personal device today, under the understanding that others would be able to do it that would not have as much of an interest, I guess, in the case. Mr. Myers was allowed to speak on his behalf, even though I have not officially withdrawn yet. For the court, let Mr. Myers answer this question.
Okay, Mr. Myers, do you want to answer this?
The question, yes. Phoenix Times is a DBA. It's just a website name to, you know what I mean, do.
Yeah, it's owned by. Hold on, it's owned by Newsmatics Inc. Is that correct?
It's
in Washington D.C.
You pay them to host the website.
Okay.
That's who hosts the website.
Okay.
It's just to do ads and stuff so that you have a website people can go to and stuff like that. And because it's out of Phoenix, they had a local guy. It's just like having an independent contractor.
Okay, but.
Welcome in. Everybody knows what a stringer is, right? That's what RP Media was. He was a stringer for the Phoenix Times. It's completely commonplace. I don't know why. They're pretending as if it's this unknown thing. So
I don't really know who this is, and I evaluate.
Do you need to know who it is? It's the media, right? I mean, the media. There's obviously a great deal of attention around this. At this point you're holding somebody as a political prisoner, right?
Who's here today, or
in
general?
In general, who the Phoenix Times? I don't. I have to evaluate.
Media company.
It's your media company.
I own Freedom Productions LLC.
Okay,
One of my
and
DBAs.
All right, so this is your company basically.
It's a DBA, but it's not an LLC.
Okay.
You don't have to have it registered to use it. It's so that we.
But your company basically opened this website as the Phoenix Times.
My company, Freedom Productions.
Yeah.
Which is multiple companies under it. started that website, so people had a website to go to, and we could sell ads so that we could have the email Phoenix Times and all that. In exchange for that, that company puts you out there, and then they run those ads on there, and they get ad revenue.
Okay. All right. Let me.
You know, we do the stories and that kind of thing, but it's just like, it's like a website hosting thing. You know what I'm trying to say? You pay them to market you.
All right. Let me hear from the state. Ms. Stiles, your position?
Couple of housekeeping items. I was able to speak with Lane earlier today. Let's not post the Venmo because the Venmo goes to him, and that's useless because he's in jail. So if we're going to send Lane anything, let's make sure that it gets sent to the legal fund. Post that. I'm going to leave the other information tagged just because we got to fill, we got to make sure that we're, these are basically for people that are more articulate with their speech than sitting down and writing a letter, so some people like to write a letter or an email, it's it's 2025 after all. So, some people like to make the call, and some people like to send the email, and I'm appreciative of both. I've got somebody in the chat right now that I've been communicating with on Messenger. I can't look at my Messenger right now, but I was curious if you might be able to send me the list of people that we need to, the list that I sent you, if you could email that to me. If not, no big deal, but I'd appreciate it if it's not too much trouble. I'm not sure if that was an abrupt end and I was supposed to be going somewhere with that or what, but I think I lost the train there.
So who do we have here today?
Somebody who says they're from RP Media, which
Aaron Queen, yeah, everybody, if you could CC me to your email, to any email you send, I'd really appreciate that. lettersoffocean@gmail.com. Please CC me to all the emails. That way I can forward these on to the appropriate party, whether it be the Attorney General or, but I'd like just an overwhelming amount of emails that I can pass along to whoever the hell is going to do something about this. I mean, somebody's got to do something, right? Somebody's going to do something, right, chat? What do you guys think? So, it's not that he listen, you know what I mean? It's not that he doesn't want your phone call, you know what I mean? So I don't want to be like, oh, don't call Lane. You guys do whatever you want. I still put the number in the description, right? So I'm not in the business of telling people what to do and how to do it. I'm just saying, like, if you're only going to do one thing, if you're going to do both, great. Call Lane, leave him a voicemail. But what he wants, the things that he wants done is, he wants... We need more attention on this. This is a public service. It's not doing it, guys. I'm not sure if we haven't actually gotten the message here, but I'm insignificant too. So I need some help, I guess is what I'm saying. So I really appreciate those that have helped thus far.
My understanding is this contractor that has been contacted by the by somebody to cover this. The Phoenix Times is not an entity. My understanding is just a website.
So this was all taken care of in advance with the person in charge down there, Allie. She's the person that we coordinated. We coordinated the cameraman, a stringer from RP Media. We arranged for him to be in the courtroom. He showed up early with press credentials on behalf of the Phoenix Times. I don't get it. Reluctant Prophet made this point yesterday that if they had given permission to the Phoenix Times, which they did, any other news organization that wanted the raw footage from inside the courtroom would have been able to go up to RP Media, the stringer for RP Media, the in-court rep, and been like, can I have that footage also? And it would have been a matter of public record. They would have had to share it because that was the company, that was the person that was given permission to be in the courtroom. Now, there was also permission given for the online link, but we had in-court permission. There was nothing that was done that was everything was done by the rules that they have in place. So it's more dirty shit. Them doing this, them withholding this new audio, not being able to find out what judge is hearing this bond hearing on the 25th, what courtroom it's in. They've made it impossible to make a timely request for media coverage of that hearing, because we're already past the 48 hours point. So any request will be denied. And you call down there to the people that say they want to be helpful, that say that they're there for the justice side of things, but they're not. They're just part of the gang. They're just part of the gang. The fuck you gang.
That the defendant opened.
Well, the rule's just very clear that there has to be that notice given to the court prior to. So if we're getting somebody else who's filming who didn't provide the notice to the court, they wouldn't be entitled. We're still live streaming, so the recording's still being put out in the public. But if this isn't the person who requested, this company isn't the one that requested the permission, then I think under the rule they're automatically denied.
I'm sorry about that.
Yeah.
I'm sorry about that.
I'm going to reverse my ruling from yesterday. This is not.
Why are we doing that? I'm so sorry, guys. We should not be doing that. Unpin that message. Thank you for spotting that. Jesus. Sorry about that, dabbler. You got some calls coming your way. You deserve them too, bro. I mean, you just dabble with the First Amendment? Is that for real? Just dabble with the First Amendment? While I enjoy the First Amendment, I only dabble. Sylvia, thank you very much. Thank you very much.
I thought I was approving, and I find it very confusing.
Can I say
And-
one last thing, sir?
Yeah.
Even though I'm not to persuade you to overturn it, but just to clarify something.
Make your record.
Yes.
Go ahead.
Is there a better way you want us to file that in the future? Because it's ultimately freedom production.
Joe, if you're asking what that number is, that's the number to the judge that can make a ruling on this anti-SLAPP. This anti-SLAPP motion. I guess I don't know why we're wasting time. We should just get right back into that, huh? We'll go back to the hearing in a minute. I'm going to have to get up in a minute, so that's what we'll do. We'll get back into this anti-SLAPP. This is when he goes back to court. See how discombobulated it was? We need to reach out to all of those fake news sources. All of them. We need to reach out to all of them. But that number's to the judge, and yeah, we need to let him know that no, it's not too late. Don't worry. It's not too late at all. I mean, don't worry about it, Joe. It's not too late, though. I know that for a fact. The voicemail will receive messages until it's full. What are you doing? Come over here. Come on. It'll receive messages until it's full. You know, that's how they work. That's how they go. So. Exactly. Yes. Please reference the anti-SLAPP, because he's the one person that can do something. Well, just work weekends. I don't care if he's working. He knows. He's not. He knows, and when he gets to work on Monday, he'll have even more. But that's the point. The point is that there's overwhelming attention on this, and the people they're dumbfounded. They're in a state of complete and utter shock that he's sitting in jail because he made a silent video where he searched the interwebs for the name Shannon Walker, for appearing on my YouTube channel in a live for an interview. He got a felony charge for being interviewed by me. He got a felony charge for being interviewed by me, taking questions about his case. He caught a felony charge. And he also caught another felony charge for the Christmas card meme that I sent to him as a joke, because Shannon Walker said that he was her ex. So, you know, if you can't laugh at the outrageousness of the situation, you know, something's wrong. So, you know, I laughed about it, and I said, oh, ha ha ha, why don't I just superimpose these faces over it, since she's a dirty, manipulative person. And it was a funny joke, but now he's in jail. So, not real funny, Shannon. I guess that power you were looking for, oh, if only, huh? Oh, if only. Let's get back to this. The next day, Mrs. Walker returned to Superior Court and asked Judge Dawn Walton to dismiss the injunction that was issued the day before and to issue a new one. Mr. Myers believes that Mrs. Walker sought a second injunction because Judge Weiland refused to remove Mr. Myers' videos. She's judge shopping, is what we're saying here. Mrs. Walker sought a second injunction on the same facts despite the procedural and legal impropriety of doing so. During that hearing, Judge Walton stated on the record that the court cannot dismiss an injunction and then issue a new one on the same facts, because that would be a voluntary dismissal by the plaintiff and would be barred by res judicia. Is that what that says? Res judicia. Sorry if I get the legal nomenclature wrong. Mrs. Walker implored Judge Walton that this was a unique situation and asked Judge Walton to manipulate the record and violate procedural safeguards to give Mrs. Walker what she asked for. Judge Walton agreed to do so, even saying that if she got in trouble for that, she would deal with that later. Judge Walton then issued an injunction on Mrs. Walker's behalf against Mr. Myers. Without hearing testimony from Mrs. Walker, Judge Walton's injunction did not order Mr. Myers' videos removed, but ordered him not to post on social media about Miss Walker. The portion of the injunction ordering Mr. Myers not to post on social media about Mrs. Walker violates Arizona case law established in Lavaro v. Cahill, 203 Arizona 482, Arizona Court of Appeals, 2002. All right. So where is it? October 10th. She went back the next day. There's two time frames. So there's one at interesting.
All right, we are on the record in C20246055. Ma'am, can you state your name for me, please?
Yes, Shannon Walker.
All right, thank you. Could you please stand and raise your right hand to be sworn in? Yes.
All right. Sassy, are you still in the chat? Are you available, Sassy? Can you do some record keeping for us?
All right, we are on the record in C20246055. Ma'am, can you state your name for me, please?
Yes, Shannon Walker.
All right, thank you. Could you please stand and raise your right hand to be sworn in? Yes.
20205, 20205, 20205. She commits her first lie by saying that she won't lie.
All right, so it's my understanding you want to modify your injunction against harassment?
Correct. I'd like to have my 2 minor children completely removed from it. I had hoped that maybe they could be listed just as minors, but because I do not believe they can, I do not want their names or their birth dates shared with the defendant.
Now, I don't think that we can call that a lie, right? Because I don't think we know, for a fact or whatever. But that's a lie for sure.
Is that it?
Yes, that would be it. That would be great.
That'd be great. Buddy, pal.
That has been modified, and she's going to give you copies for your records, okay?
Thank you very much, Your Honor.
Hold on. Hold on. Thank you, Clifford. Count 12 is duplicated. 13 is missing from the Google Drive version of the anti-SLAPP motion. Huh. That sucks. Don't tell them, they probably won't catch it. 4:45. So, okay. This is 2:01. This is 2:01 p.m., right? We go through here, 2:01, 2:01, 2:01. Alright. Let's finish this one right here, okay?
So that has been modified, and she's going to give you copies for your records, okay?
Thank you very much, Your Honor.
All right, we are.
Alright. So that ended that hearing right there. And this one, 4:58, starting right here, but there's one in between, right? Sneaky, right? Why are you trying to be so sneaky? Why are you guys trying to be so sneaky? So this is, I think this is the one they gave us, but they were hiding stuff from us. Sneaky.
All right, we are.
All right, so we can keep it just as two time frames on the same date. Sassy, I will. Right now we're only working with that one lie, that first lie.
On the record in C20246114, ma'am.
All right, so did you guys catch that? The case number changed. The case before was C20246055, and now the case number has changed because they did that dirty stuff.
State your name, please.
Shannon Walker.
All right, could you please stand and raise your right hand to be sworn in?
Yes.
4:45:29. 4:45:29. 4:45:29. That's a lie. She lied about whether or not she was going to lie.
Okay, what did you want to do with this one?
So, originally, when I filed my injunction, I have 2 minor children. They were listed on it. I came back today to have that amended, and their names are still listed, and my understanding is that the defendant can ask for those documents. My concern, given his pattern of behavior, is that he will display their names and encourage people to he will incorporate that into his content. So
He will incorporate your kids into his content? Is that serious? She's serious? Who believes that Lane's gonna incorporate the kids into his content? I can't call it a lie.
I'd like to dismiss that order and start a brand new one.
Oh, with the same allegation.
Correct, exactly. That's what I was advised to do, is the only way to be able to protect that. My hope is that the original, the one that has been canceled or will be canceled, will be sealed, so that's not information that is available to anyone.
Listen to her make up the rules as she goes. This is what I need you to do, Judge.
Because typically when someone files an order of protection and it's granted and then they dismiss it, an order of protection or injunction against harassment, and then they dismiss it, that's it.
Right.
So,
If there was a way to remove my minor children's names from the original, I would.
Please break the law for me. Please.
Be very happy to do that, but I was advised by the people downstairs that that is not possible.
So let me get this straight. The people downstairs are dispensing legal advice? Okay. That must be another one of those special privileges just for the select few, probably just for the state actors.
So this is the approach that I was advised to do.
did you already submit it?
I did. I filled out, my understanding is they said that hopefully we could dismiss the original one and then have my new injunction against harassment petition approved. And I understand it's kind of a unique situation, but hopefully one that you can see might be warranted based on the pattern of behavior.
What pattern of behavior? They don't even talk about it. Give me a break with this person. All right, I gotta make an abrupt segue for a minute. So we're gonna go back to this before we get back into the anti-SLAPP. I'll be right back.
Doesn't have its own website to give you.
Okay. You can file something. I'm not going to give you legal advice. I just did not understand who was making the request.
He's not in the
and
club.
It was very confusing to me. And I'm concerned about the nature of the charges in this being a harassment case, about who's doing what. So I'm not going to allow, I'm going to deny that for today's hearing.
May I say something, Your Honor?
Yeah, hold on. There were a couple of things I had on my list here before we.
Okay, but I wanted to add to that could change the prior ruling, maybe the reason for as well. Your Honor, we still believe that under the 122H, Mr. Myers should at least be able to use his personal audio recorder to record the hearing for his own purpose. I think that's what the rule permits. The reason we didn't object more at the last hearing is because the court was going to allow a separate company to essentially film this. We would have concentrated more on that objection and perhaps Mr. Myers would have filed more on why 122H would allow him to do audio recording today. That's
I did
concern,
ask for it.
because the only reason we accepted the court's ruling without further argument, or Mr. Myers would have filed more motions, was that he understood the court was going to allow some sort of video today. I don't know what YouTube is showing. I don't know where it's being live streamed, how people can access. I'm just not familiar with it. But I think Mr. Myers at least would like to use his personal recorder.
They totally do, Dad.
Give notice about it and be able to record this hearing.
I deny that. So let's. One thing I want to do quickly so I don't forget is Mr. Myers filed a motion to exceed the page limit, which I'm granting. That's for his anti-SLAPP motion. So
Thank you, sir.
you didn't have an order, so I just want to do that on the record. All right. Next.
Thank you sincerely,
Before we address the defendant's motion to represent himself, Mr. Parvin, you wanted to say something.
Yes, it's come to my attention that rather than file all charges at once, where Mr. Myers would, I guess, be bailable as a matter of right.
Please forward to
this
me.
whole situation seems to be piecemeal filing. There are
I'll be right
Tucson
back.
Police Department officers, I don't know if they're in this room now or if they're waiting outside, ready to arrest Mr. Myers on new charges that will be consolidated with this court, which will therefore deprive Mr. Myers opportunity to respond and represent him pro se, therefore forcing me to be on this case against Mr. Myers' wishes to represent himself. I ask that we be, if the state seems to know what's coming, that since this court has jurisdiction for these new charges, I ask that we do an initial appearance today immediately and set release conditions so that Mr. Myers can continue to represent himself, because otherwise we're going to have a real problem after this court grants this motion, because now he needs new attorney on the new initial appearance. And then I'm back in this with the same kind of Feretta motion doing this again. We got a real problem, Your Honor.
Well, so we have a CR pending now. Defendant's been held over. and I'm going to rule on that. I don't know what's going to happen if they're going to file an amended indictment, if there's an arrest and they want to go forward on an amended indictment. That there's nothing pending that I could. I understand your issue, but there's nothing there's nothing pending that I could address.
Well, I wonder if the state has any information at all, because considering there's an arrest, that he's going to get arrested on new charges. I just talked to the officers, so that's kind of it's going to pose a real problem here. How is Mr. Myers going to respond to motions pro se? And at the same time, how am I going to be withdrawn? He needs representation. And then if there are new charges on new arraignment, the court's going to have to reappoint me again and do this all over again. So again, does the state have any information of all? Because I mean, these officers seem to have information.
Ms. Stiles?
Your Honor, I notified defense counsel yesterday that there were likely new charges coming.
Okay.
And so this defendant just happens to be committing new offenses. And so he faces, just like anybody else who would be ongoing criminal activity would be facing new charges. That's the position he's in. And
Let me ask this. If that occurs and it proceeds and there's an indictment on the new charges, would that be in this CR or a new CR?
It would be a new CR.
Okay. And that would be assigned to me, because typically we assign all matters to the same Superior Court judge. So, but those aren't pending. Would you agree with me that there's nothing I can take action on with respect to that? It's speculative.
There's nothing that he would have to go through the process, but there's nothing currently that would be in front of the court for the court to be able to do anything on.
But the new charges wouldn't affect these pending charges, correct?
Correct.
Okay.
It would, Your Honor, because it's going to affect potentially his bail eligibility, and that's a problem if there's no basis for the new charges. That's the whole point of Mr. Myers' SLAPP motion. Now, I would have filed it slightly differently. Maybe I would have done a motion to dismiss under the grant, or motion to remand once the grand jury transfer comes in. There are things I would have done differently, Mr. Myers, and I would have taken more time to do it. That's the reason I have to withdraw, so Mr. Myers can do everything the way he wants, and he may or may not be, right or wrong, doing it different than me.
Right.
But that's a real problem, because if I don't know where the officers are, they work here. I don't know if they're in here now and can give information. But if this court proceeding concludes, we go out there and Mr. Myers gets arrested, brought into custody. He needs a new initial appearance. I don't know when that's going to be. Obviously, the court's going to need back in on it. Are we going to have to reappoint me again and then go through a new withdrawal? And then I'm wondering, at this point, I'm just trying to think for.
Well, we could do a couple things. We could put off your motion if you'd like to withdraw. I mean, that would be the.
He needs his motions filed. Sorry.
Hold on. The court system goes in steps, and we're at one step right now. I don't know if he's going to be charged in a new case or not. I have no information on that. But if you in consulting with your client would prefer to stay on now, and then we could reset this, or we can go forward. That's your choice.
I think what's going to happen, as procedurally crazy as this will be, we'll proceed today with the motion to withdraw and Mr. Myers' request proceed pro se. My understanding is all of his motions have been filed, which will prompt the state needing to respond, and that way at least everything's filed. And I'm guessing I will be notified of the new initial appearance. Now, again, I have a calendar as well of my other OCAT cases, and I'll have to rearrange things to try to come to the new initial appearance. I'm guessing I'll be appointed again, and then on whatever new case is, we'll have to be right back here on the new case and do this again. I guess it needs to be done twice, is from what the court's understanding is. But we'll do this today. We'll get through it, and Mr. Myers, I will be with you. We'll talk to the officers and find out what's going on before you are arrested.
Yeah, I think that, again, we have to concern ourselves with what is currently pending, and I can't speculate as to, the different steps in the criminal process, and I don't get the case back until the defendant is held over if there's a new case. So, I think
this is just a very unusual case.
They did this on purpose.
Hold on. I'm just explaining to the court why this. I understand everything the court's saying. I just hope the court understands how rare this type of situation is.
It's unusual, but people actually pick up new charges all the time. It's kind of a.
But I haven't done anything.
I understand, but I'm saying it's unusual where a person wants to represent themselves and respond to motions, but normally I should say the same attorney can help them while they're in custody.
They're doing this so I can't type at my computer. They just want me away from my computer.
Okay, all right. That's not our issue today. Today our issue is whether you want to represent yourself. So, and I know the last thing I wanted to mention is that Mr. Myers, I understand that when you're filing things through our e-filing system, that you're having a hard time marking action for a copy to go to chambers. And we checked on that, and there is only one filing system, and it is possible to mark action by the division.
I
So,
don't know where that is on there.
Mr.
I even
Garvin,
called the clerk and went over it on the screen with her.
Mr. Parvin, have you tried to go over that with him? Just show him how it
Actually, on the
works.
filing system, honestly, I've had some issues there as well, where even if it gets there, it goes to a pile. I find it much easier just to deliver directly to the clerk with the courtesy copy, because I know then there's a response that's been received. You don't always know it's been received if you use the action online. But I believe, I understand the court will understand if it doesn't get to them, there's a reason you tried. I don't think the court's going to hold that against you, Mr. Myers.
The only thing I could see on there is it says emergency judicial action.
You don't need that.
Right.
There is a way to do it. It's just always, I should say, more complicated.
I don't know if it's because I'm pro se and they won't let me just send things directly.
No, it's only one system.
Well, it won't matter now because they're going to arrest me and play games.
Mr. Parvin, what would you? I wouldn't. If you have problems with the system, how do you do it?
Well, it's not that I've never had problems filing anything.
Right.
I've had problems where it thinks it sent it to someone, but it doesn't. It maybe it's just on someone's desk or doesn't get printed out, or it's in a list of documents. So I find it best, although as the attorney, it's easier for me to just follow up with for example, the state or the chambers and say, did you get this? And sometimes I say, could you please email me a copy? And that way I have it. But I understand Mr. Myers' situation. It's a little different. I think it'd be best to use the system where it gets to your court at some point. And if the court does not have it, I inform Mr. Myers it's still filed on time, and then the court would just explain, okay, it's not going to use that against Mr. Myers simply because it finally got to you at a later time.
So the issue it's important that we get copies. What I don't want
Is that what it sounds like? A bunch of fed actors? That's funny.
is for Mr. Myers to email us all this stuff. That's not just a document. If we don't get a copy, we don't know it's filed. We don't keep a running. We don't look at every case all the time.
Right.
We take action because something's served on us.
And that is the problem I've had before, when I thought I didn't follow up and I thought it was served on our court and it wasn't. Again, it was easily fixable because we just got an extension of time limits. But I understand Mr. Myers' concerns. That does happen sometimes where you never know for sure if the person receives it. You don't get confirmation unless it's by email.
All right, so I'm going to amend my order from yesterday that Mr. Myers can provide a courtesy copy. When you email me, Mr. Myers, to email us all this stuff. That's not just a document. If we don't get a copy, we don't know it's filed. We don't keep a running. We don't look at every case all the time.
Right.
We take action because something's served on us.
We take action when something's served on us. We take action when something's served on us. 36 hours, probably. No, probably not. Well over 24 hours with the anti-SLAPP motion. He said in this hearing, I'm not sure if we've already gone past the point. I'm not sure if we've already gone past the point, but he, I just lost my train of thought. But in either case, he's got the SLAPP motion. He can take it. He can take immediate action. Oh, he said in the hearing that he had, perused it, and then Lane's attorney said something. I can't remember what he said, but Mr. Parvin. But he said he perused it, whatever that means. So I'm sure that after the hearing, he took some time and started. And I think I said this earlier. He took some time and started reading it. But once you get past that, I mean, we spent 3 hours to go through one paragraph earlier, exposing the lies. 33 lies, was it, Sassy? 33 lies. Yeah, Lane's in jail. Guys, reach out to any news company, the link to the Anti-SLAPP is in the description. Send it to any email that will receive emails.
And that is the problem I've had
He takes action when something's served on them.
before when I thought I didn't follow up and I thought it was served on our court and it wasn't. Again, it was easily fixable because we just got an extension of time limits. But I understand Mr. Meyer's concerns. That does happen sometimes where you never know for sure if the person receives it. You don't get confirmation unless it's by email.
All right, so I'm going to amend my order from yesterday that Mr. Myers can provide a courtesy copy. When you email me, Mr. Myers, you also have to copy the state prosecutors, okay?
I guess.
All right.
I feel like this hearing is.
Hold on.
I mean,
we're just talking about procedures.
but I know I'm going to get arrested when I walk out, and they're going to try to hide me from my computer, so I can't even.
You're going to get a new hearing on that.
How am I going to be able to even file anything in this case if I'm in jail?
I don't have any jurisdiction over that. We're talking about this case and what we're doing today.
I don't agree. You know what's going on. You saw the slap. It's going to be a slap in the next one.
The court's not going to read everything in 30 seconds.
Okay.
It takes time.
Mr. Myers, we're talking about procedures in this case, okay? I'm trying to help you so that you can hold on, so you can represent yourself.
But I'm
And hold on. You don't talk over me.
I'm not apologizing. Go ahead.
I'm just trying to find a courtesy copy. When you email me, Mr. Myers, you also have to copy the state prosecutors, okay?
I guess.
All right.
I feel like this hearing is.
Hold on.
I mean.
We're just talking about procedures.
But I know I'm going to get arrested when I walk out, and they're going to try to hide me from my computer, so I can't even.
You're going to get a new hearing on that.
How am I going to be able to even file anything in this case if I'm in jail?
I don't have any jurisdiction over that. We're talking about this case and what we're doing today.
You know what's going on. You saw the slap. It's going to be a slap in the next one.
The court's not going to read everything in 30 seconds.
Okay.
It takes time.
Mr. Myers, we're talking about procedures in this.
All right, so maybe he didn't say that he had looked at it, because that's the part I remember as him when Mr. Parvin said the court's not going to read it in 30 seconds. So I was mistaken.
Case, okay? I'm trying to help you so that you can hold on, so you can represent yourself.
But I'm
hold on. You don't talk over me.
I'm not apologizing. Go ahead.
I'm just trying to find a procedure so that you can file things properly so that I get notice. But I don't want to hear the arguments and the invective towards the other side.
I don't.
So I will amend my order that when you file something, you could email the state's attorneys, Ms. Stiles, all right? So you should never email something to a judge without the opposing party knowing about it.
Talking about like when you add the names? CC,
Yes.
right? Okay.
CC, yes.
And I'll suggest, Mr. Myers, no commentary. What I do, you simply add the motion. You say, this is what the motion is in the body. That's it.
Right, then we'll make sure we have it, but I don't want, you've added a lot of stuff in the motions that.
Yeah, because this is all a BS case.
Okay, but it's not proper. I can only consider what's filed in the court file.
I understand what you're saying, 100%.
All right, so are we ready to proceed to the defendant's motion to represent himself?
Yes, Your Honor. Mr. Myers, you have filed everything, right? So even if you're brought to custody, you have nothing else to file at this point.
As to the motion to represent yourself?
You're talking about the motion to represent myself.
Right.
I filed the notice of appearance with you. That's what we're
Okay.
having
I'm
a
saying
hearing
even your
on.
SLAPP motion's filed. Everything's
My SLAPP
filed.
motion's filed, but I had other stuff, Rule 15 and all that, but they knew what they were doing. This is dirty
Okay.
tricks.
I think everything's filed, Your Honor, where we could proceed.
All right.
That way you're not harmed.
My thing is if you let...
Hold on, Mr. Myers, we're proceeding.
I know. He was saying that initially a few minutes ago that, there was an option of, waiting a little bit to see, because, they might pull more tricks out of their sleeve. So the thing is that in order to make sure that I have an attorney, but my thing is I'm loath to do that because I want the SLAPP motion heard immediately. So if I don't go pro se right now, that would delay you being able to act on the SLAPP. You know what I mean?
Correct.
But it's also knowing that you left the house today with your wife's car half fixed, and now I got to.
Which he could take action on any second. I mean, it's within his power to do so. Every news station that you guys can think of, small ones on Facebook, anything to spread the message, send them the anti-SLAPP, email the judge, CC Khan over to it, CC Styles to it, for sure. I think I said it earlier, but no, let's not post the Venmo because that goes to Lane and it's useless for him. The legal fund, send it to the legal fund. Yeah. Let's get through this.
To jail, you know, I mean, my wife can't get to work as an attorney in town because this is the level they want to take it to. I don't know, you know what I'm saying? What's gonna?
Okay.
Because now I have serious.
That's another one, seek and destroy, and thank you very much for doing that. Message the Attorney General for sure.
Concerns about these people being ethical.
Your Honor, I will accept the appointment on the new charges, consider the fact it'll be a separate case number that will address that. That way I'll be appointed when you, on the new case, if you're brought to custody.
Will it be brought
and you
in?
can still, eventually. And then we'll do this again on the second case.
So, yeah, there are no new charges pending.
Yes, there are. They're waiting in the hallway.
Hold on.
No.
You'll get an immediate court date.
I don't understand, and, you know, granted, I'm pretty ignorant on Arizona law or Arizona courtroom procedure, but what would have prevented the judge from turning to Miss Stiles in that moment, saying, Miss Stiles, are those men in the hallway here to arrest Mr. Myers on charges originating from your office? Because that's the only place that they can originate from, right? It wasn't, he's not being prosecuted in Tucson City Court, is he? Oh, I forgot, guys. Wow. Hold on for a second. I need to get something off of this.
There's a process. If you get arrested, then there'll be charges filed. They'll take it to the grand jury. If there's a true bill,
well, how would
It's the one where they got 10 days to get the grand jury. Okay.
So there's the new charges are not before me.
They're gonna arrest me when I walk out.
It's not before me.
But then I'm gonna go to jail and I won't be able to talk to you.
I was hoping it was already filed, like some sort of indictment. That wasn't the case. That's why I brought it up. Unfortunately, it's not yet filed, which means you have to go through the process, which I believe I told you about 10 days.
My car's sitting out there.
Okay. We're here on.
Why can't you be respectful and professional?
I'm trying to be.
No, not me and you. These people.
We're not talking about that.
We are though, because you know that as soon as I walk over here, and then I'm not. How am I going to be able to respond? If you say if you need further briefing in the SLAPP or something, and I can't do it, then I'm screwed.
No, it doesn't work that way. If you're in custody and can't respond, we'll give you additional time. We won't work that way. I'm not going to. No, it doesn't work that way. You're not going to be prejudiced in this case because you've been arrested on new charges. Okay?
Yeah, they're going to say that I committed a felony while I'm felony for a bond.
That's different.
For making a meme.
That's different. That's different than your SLAPP motion. All right.
Well, I'm going to put a new one on the next one.
Okay, you can do that if there's new charges filed. That's not what we're here for today. Let's
Well,
really.
I'm scared that if I give up my right now, I won't be able to have it in the next case.
Have you right to rep attorney?
Yeah.
No, it's a separate case. I accept it. I'll accept the appointment on the new
So you get a new attorney in the new case, and then you can waive your right to that attorney, and you can file a SLAPP motion in that case.
So there'll be CR over here, CR over here.
Correct.
Judge whatever, judge or you maybe you.
Same
okay,
judge.
So it'll be 14 over here, whatever the new over here.
My understanding is the concern was I'm not ready to file a SLAPP motion. I don't know if it's proper or not. It sounds like there is some merit, but I would have done it differently, and which means if I stay on this case, technically the court has to say it goes through me. That's why I'm withdrawing so that your motion will be filed.
That's what I'm trying to say.
Okay. All right. So, Mr. Myers, I can have you stand and be sworn by the clerk first. Then I'm going to ask you some questions about your waiver of right to counsel.
You solemnly swear to speak the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, have a seat. Mr. Myers, I'm going to ask you a bunch of questions, okay? And it's just the rules I have to follow. before I can make a decision to allow you to represent yourself. And they're very standard questions.
Okay.
And it's from Criminal Rule 6.1, okay? So, do you read and understand English?
Yes, sir.
What's the highest grade you finished in school?
12th.
Graduated high school?
Well, I have a
GD?
No, I have a college diploma and 2 technical degrees, a paralegal degree that I got in prison.
Okay. Are you under the influence of any drugs, alcohol, or medication?
Right now?
Yes.
No.
Have you ever been diagnosed with a serious mental illness?
No.
You have the right to counsel for all stages of the proceedings, including appeal. And if you cannot afford counsel, you have the right to a court-appointed lawyer at little or no cost to you. Do you understand that?
Yeah, so I can go back to a lawyer.
Correct.
Right.
If I allow you to waive your right to an attorney, do you understand that you can change your mind and request to have an attorney represent you going forward?
Thank you.
Is that yes?
Anytime moving forward later on, I can go for myself for a little while and then say, you know what, I want a lawyer.
Right.
Motion?
Yeah, you would file, or you could just say in court.
Okay.
All right. So do you understand you have that right?
Yes.
All right. Next, I want to talk to you about the risks of self-representation. First of all, I want to go over the charges. So you've been held over for trial on an indictment that was filed on March 7th, and there are 14 counts to that indictment. Counts 1 through 6 are each Class 5 felonies. If the state can prove that you've been convicted of a prior offense, it takes you out of first-time offender status and makes you a Category 1 offender, which means you're not eligible for probation. So if you're convicted, prison only. Each one,
All right, sorry about that. I had to send myself the man, I'm dumb. Just can't get it together, can I? All right. Of course, I sent the wrong one.
the mitigated range is a quarter of a year, that's 3 months, and the aggravated range is, on count 1 is a quarter of a year to 2 years. That's a Class 6, and then the others are all Class 5s, counts 2 through 6, where the sentencing range is a half year to 2.5 years. And then counts 7 through 13 are Class 1 misdemeanors, no prison available. There is probation available, or I could sentence you to 6 months on each. And as to all these, some of them may have to run at the same time, but some can run one after the other. So you're facing a substantial amount of prison. And then the last count, count 14, the stalking is a Class 3 felony. Again, if you're a Category 1 offender, the sentencing range is prison only 2 to 8.75 years. So you're easily looking at the possibility of a long time in the Department of Corrections. Do you understand that?
Can I say something back?
I want to know if you understand that.
Yeah, that's why I wanted to clarify something you said right at the beginning of that little section. About the felonies prior.
Okay, and you're under oath, and anything you say can be used against you.
I was wondering if you meant, do they have to be in Arizona?
No.
Okay. Yes, I
They have
understand.
to be within a certain time period.
Yeah, they're
That-
26 years old.
Hold on, there is a way to strike it, but that's down the road.
Okay.
Okay.
So to answer the question corresponding to that little segment, yes, I understand.
Okay. Now, if you do represent yourself, You'll be held to the same standard as lawyers. Do you understand that?
Yes, sir.
And you, I believe you have a paralegal degree, you said? But you understand that your lawyer, Mr. Parvin, has attended and graduated from law school and has practiced as a lawyer for a long period of time. Do you understand that?
Yeah, my wife was a judicial law clerk for 8 years too, till they got her fired in this case.
Okay, so what I'm saying is, if you're represented by a lawyer, you'd be represented by someone who went to school for a long period of time and has practiced for a long period of time in this area and has a lot of knowledge and wisdom and experience that he can bring to bear in representing you that you're just simply not going to have by not being a lawyer. Do you understand that?
Yes, sir.
All right. If you represent yourself, you'll have to do certain things like pick a jury. Have you ever picked a jury before?
Yes, sir.
You have? Okay.
And I won the case.
All right. You have to make opening and closing statements, and you'll have to cross-examine the state's witnesses and examine your own witnesses. Do you understand that?
Yes.
And you may find it difficult to make arguments to the court. Again, if you watch your lawyer do it, he's very professional and smooth, and it may be harder for you to do that than it is for him to do that. Do you understand that?
I do. You can go to school for 10 years and still not have ethics, though.
Okay, but that's not the question before us today. The question is training and experience. And what I'm trying to tell you is that if you represent yourself, you're giving up a resource of someone who's very trained in this area. Now, currently, you're out of custody, and I understand that maybe you'll be in custody. If you're in custody, as the case proceeds, it's much harder to prepare your case
Obviously.
than it would be for your lawyer to prepare your case. Do you understand that?
I do, and that's why I'm trying to figure out why couldn't they just do this all at once?
Okay. And things that are hard to do would be to subpoena witnesses, review disclosure, and interview witnesses. Do you understand that? Although we will make provisions to try to make that as clear and as...
Raya Hoot, I'm sorry if you said something earlier. Did I get what today? This was the hearing from yesterday morning. I don't know. For some reason my phone's not connecting back to my camera. So, whatever. But anyway, I guess that means I can read the text that I was... There it is. Bear with me, everyone. You'll be able to see my beautiful face in a second. Don't. Ladies. Ladies. Be patient. Be patient, alright? I'll be back. I'm coming back. There I am. Alright, so Raya Hoot. What were you asking? Did I get that today? Cash App. I did see a couple Cash Apps today, but I haven't been on that app yet to hit the little heart button yet. So, I did. Let me see if I can do this. I got one from Yahoo. Thank you, Yahoo. No, I got two from, that's you, Raya Hoot. I got $13. Thank you very much, sir. And Yahoo sent me $10. I appreciate both those. Anyway, let's wrap this up. No, let's not wrap this up. I was pulling up the text messages. That's why we got off on this whole tangent to begin with. All right. So there's some additional details that I obtained today through my exhaustive investigation. And those details are as follows. and you can add them into any emails you're sending or anything like that. Can I copy and paste this? Preview. Oh, I can. All right. Additional facts showing First Amendment retaliation. Mr. Myers has filed a notice of claim against the city of Tucson for the booing case. Settlements for cases with comparable facts in Arizona range from $200 to $300K. That'll hit you right in the budget. Or maybe it'll hit your insurance premiums, but it's going to hit you either way. Either way, you're getting hit by it, right? Number 2 is Matt Walker is assisting the state with this prosecution. This current one. The state disclosed Mr. Walker's attorney work product and its disclosure. So let's just make sure that we're flushing out exactly what this is. The city of Tucson prosecutor is working in conjunction with the Pima County prosecutor to railroad Lane. The Tucson city prosecutor is married to the alleged victim in this case, and that's appropriate, and that's ethical. All right, I don't know that this is actually, I'm not going to say this one because I don't know I don't know if it's a fact. I know the other stuff is a fact. The deadline for the brief in the appeal of the injunction is coming up soon. The state is aware of this and has made additional efforts to detain Mr. Myers in an attempt to prevent him from briefing the appeal. You guys see what's going on? See what's going on here?
Possible. It is just more difficult if you're in custody. Do you understand that?
Yeah, I understand the game.
It may be harder for you to file papers in court. Today, we've talked a little bit about the
Nothing to
difficulty.
see here,
We're
Michael. Keep it moving.
Trying to mitigate that, but you understand it may be difficult to file papers in court as compared to your lawyer who does it all the time.
File with court, you mean if I'm in jail?
No, just generally. Just being
You mean throughout the litigation?
Yeah, just being a pro se person,
Yeah.
it may be harder for you to do it.
Get them in and stuff. Right.
All right. And then when you represent yourself, you're going to have to stand up and argue to the jury, and in your presentation, you may have less credibility than the lawyer would have. Do you understand that?
Not in this case, but yes.
All right. Well, you think I'm just telling you that's a possibility.
I'm not the optics. Yes.
All right.
That's what you mean, right? The optics of it.
Yes, exactly. The services of an attorney can be of great value in determining whether the charges against you are sufficient as a matter of law, whether the procedures used in investigating the charges and obtaining evidence
the judge
against you
almost
is
seems
lawful,
reasonable,
including the lawfulness of any search, seizure.
I came away from this hearing thinking to myself, he didn't seem completely unreasonable. But it's 10:10 Eastern on Friday the 21st. Lane's sitting in jail.
For police questioning. If an act you may have
gotta
committed
leave the
actually amounts to
email
the
up,
crime for
Michael.
which it's charged, or if you have another valid defense of the charges, or if you're found
gotta
guilty,
leave
whether
that
you should be
email up.
placed on
Please,
probation, required to pay
reach
a
out.
fine, or sentenced to a term of incarceration. and whether appellate review could be justified. Do you understand that? That services of attorney can be of great value in determining those matters?
I do, and if it gets past the SLAPP motion, you never know. I might have to get one.
Okay. And as we've gone over, if you're found guilty of the offenses charged, that you do have face the possibility of being sentenced to a term of incarceration, even though you've given up your right to an attorney. Do you understand that?
Yes, sir.
Having gone over the risks of self-representation, is it your choice?
Do you guys know how big this is? Seriously. Do you guys know how huge this is? What's going on right now? This is unprecedented. Unprecedented in, we'll call it Arizona law or Arizona court history.
Today that you still wish to waive your right to an attorney in this matter?
In this matter.
In this matter,
Right.
this CR matter.
Not whatever they're going to do out there.
Correct, this case, this
Yes.
pending before us. And the answer to that is yes?
Yes, sir.
Has anyone promised you anything if you waive your right to an attorney and decide to represent yourself?
No, sir.
Has anyone forced you or threatened you in any way to waive your right to an attorney and decide to represent yourself?
No, sir.
Have you had the opportunity to discuss your decision to waive your right to an attorney with the attorney that's currently representing you?
I have. We didn't know this was coming, though.
Okay, but again, do you think you need to talk to your attorney more before you decide to waive your right
Not
to a
in
lawyer?
this case.
Okay.
I have one concern, Your Honor.
Sure.
Is the SLAPP motion can be done any time, and that's the only concern I had. I didn't really feel comfortable filing that. What has a time limit that I'm worried about is a remand to the grand jury. I don't know when the transcript's coming in. That is a motion I would strongly recommend looking into filing. I don't know if Mr. Myers is capable of filing that motion in custody or even knows when he'll get it, but that's a strict time limit that really can't be waived by the court, although you can get extensions. I know how to do that. Mr. Myers may or may not know how to do that. That's my only concern. But again, I'm not going to file that SLAPP motion. That's Mr. Myers' motion. That's why I need to be withdrawn. I don't know if there's a way to appoint me as advisory counsel and give me permission just for that one basis to look into the grand jury and file that one motion only.
Well, if I grant his motion, I'm going to appoint you as advisory
As
counsel.
advisory, can I still file that motion on his
Well, hold
behalf?
on. No, because then you're his lawyer. Hold on. What's the deadline for filing a motion for remand is based on what date?
So it's 45 days after they receive the certified transcript, so.
Okay. And you haven't received that yet?
I'm not, but I'm worried Mr. Myers in custody would not know how to do that. I would. That's my main
Okay.
concern with this.
I could extend that to 60 days. Ms. Alves, do you have any objection to that?
No, and like I said, I don't know when the transcript's going to be ready, but they still.
Okay. All right.
We're not up against that timeline, so if they need more time even than that, we can always keep
Yeah.
adjusting it.
So for today,
But can he file it, or does it have to be me?
It has to be you.
It has to be me.
But I will buy you time. I'm giving you time. Sorry.
yeah. Okay. So what we're going to do is today I'm going to enter an order, and I am ordering that the defendant has 60 days to file a motion to remand once the defendant receives a certified copy of the transcript of the grand jury. So that's 60 days. If we're bumping up next to that, then Mr. Myers, you'll have to ask for additional time. Okay? What?
If I'm in jail and they mail it to my house, I mean, how would I even know I got it?
Don't you?
Send me copies, even though advisory.
So the clerk's office sends out the copies, but we'll make sure that he gets it.
Okay.
He'll get access to all his
Yeah.
disclosure.
If you're advisory counsel, I believe you
Sure.
continue to
If I
receive.
get notice of
so
court dates,
trustworthy.
I don't know what the rules of disclosure are for that.
Okay.
So we will make sure that Mr. Parvin also has a copy of everything, so he gets everything so that he can go and discuss it with his client. So even though Mr. Myers is representing himself, he has his advisory counsel, so we make sure that we're still sending things through Mr. Parvin.
Okay.
But that's not really representing myself.
Well, do you not want me?
Well, no, I'm
you have the
saying-
right. You could get me off if you want.
I'm
me.
just
You
trying to
want-
make sure that, like, if they're gonna send stuff to him, is it what then he gets it to me?
Yes.
So-
He's your advisory counsel. He'll still be able to communicate with
But
you.
I'll also get sent a copy, right?
You should. Correct.
It's going to send to both, is my understanding.
Yeah, there may be, if depending on his custody.
Hey Bev, that was on a different on a different case. That was the Arizona case that he had 2 attorneys on. But William Parvin is his attorney on this case, and now he is going to be his standby counsel. And he was appointed at the bond hearing on the new charges, so he'll have representation until he files the same motion or until the charges are all enjoined.
Status, there may be different things with the media, but like we work with that all the time with people who are in custody representing themselves.
Okay.
So he will have access to everything.
The next thing is,
You hear
Mr.
that, right?
Yeah.
You heard what they said?
Yes.
Yeah, they're dirty.
Mr. Myers, to waive your right to counsel under the rule, you also have to sign this notice of waiver. So Leah, can you hand that to him? And it's on
Did I say something
page 2
other
that you
than
signed
New
it, and I
Mexico?
signed it
I'm
as well, and then
sorry,
it gets
New
filed with
Mexico
clerk.
for sure. He had Blair Dunn and Zach Cook.
Do you want?
All right. The defendant, Mr. Myers, has signed the notice of right to waiver of counsel in open court. We'll put that date on there. The date is the 20th. Court makes a finding that after discussing the matter with the defendant and have observed his demeanor, that he has knowingly, intelligently, and involuntarily waived his right to counsel. The court will appoint Mr. Parvin as advisory counsel.
Is that what happened?
And then we will
apologies
talk
for
about the schedule here. So there's that. That gets filed in open court. And
Your Honor, I don't mean to interrupt. I just got a text message. Someone mentioned they can't hear any audio on the broadcast. I just want to make sure this whole thing was recorded with audio.
yeah, it says it's streaming active.
Okay, I'm not
So,
sure why I was sent that text message, but it's just what I was told.
okay.
I just can't hear any audio on the broadcast.
All right. Let's look at the schedule. So we have a motion to modify conditions of release scheduled for the 27th. And as to that, Ms. Stiles, I'd like, if you're going to present evidence at that, which I assume are videos, is that right?
That's correct.
Could you provide those copies to me beforehand so I can watch them beforehand, so we don't have to just sit and watch all of them? And then you're obviously going to disclose copies to the defendant as well, correct?
Yes, absolutely.
Okay.
Your Honor, how would I prepare for this in jail? You just told them to disclose all this. We went on. They could have told me this yesterday. They knew we were setting this hearing. They knew that I needed the evidence. We went over this yesterday. We made a big whole stink about making sure I had the disclosure so I could have due process ahead of the hearing. And now I'm just being I was just appointed and under the understanding that, after this hearing today, they would provide it to me and I would go home and start getting, preparing for next week. Why they couldn't just bring this up at the next conditions of release hearing, you know what I'm saying? So that I could actually make cognizant arguments, because now they're just going to give you, it's like, I'm not even, the evidentiary hearing is a hearing on the merits of their motion. Like, I don't even get to make arguments because they're going to put me in jail and avoid me. And that was the whole point. I wanted you to order them to disclose it to me. And you said, well, we got time for that. Miss Stiles, make sure you disclose it to him so he has time to get ready for the hearing next week, right? So they're saying, so all of a sudden you just asked her right here in open court, Miss Stiles, I assume you're going to be showing me this, that, or whatever. Could you send it to me, right? So that implies to the court right now that they knew as of right now what they're going to send, or yesterday or any of that, and they could have apprised me of this ahead of time, but they're waiting to right now to put me in jail, and then they're going to show you the evidence. I won't get to prepare for the hearing. I'll come there looking like a dumbass in a clown suit. And then they'll be like, oh yeah. And I had no time to prepare, no time to argue. And my lawyer can't prepare because I just took him off the case. This was all a setup. They could have.
Okay. So, Mr. Myers, a couple things. First of all, if you're in custody next week, then there wouldn't be a need for a motion to modify conditions.
What are we doing?
And so we would put it off, or if you're not able to prepare for it and we're there, you can tell me that you've been unable to prepare for it. What the state said yesterday, though, was all the videos that they're going to use come from you, so you've actually seen the videos.
But that doesn't, sir, that's not so I'm supposed to assume which ones they're going to use? I don't know I make hundreds of videos. So that's like saying we're going to use something the color blue.
Okay.
That's not properly telling me. Now, if they're talking about for the whole case, like in the 14 counts, that's what I assume they meant. But if they're talking about specifically to prepare for the evidentiary hearing and they're going to bring up videos there, they need to tell me, because those are different. Because remember now, this is a hearing for the conditions of release, which means things that happened after the indictment, right? So now I can see for the things in the indictment, absolutely I should know because I have the indictment and I could read it in the police reports and all that, right? But I'm not. But the conditions of release hearing are things that have happened since then. I haven't been indicted, or I haven't been. You get what I'm saying? Given disclosure specific to, because when they filed their motion to modify, they didn't include no exhibits, no nothing. There was just, hey, we just want you to take our word for it. Trust me, he did this. And so, and it was not even him, it was somebody else. And so what I'm saying is that how do I, not for the indictment, which is, like you said, you got time for that. Specific to this hearing, now they're going to put me in jail. And they could have, it seems like they know what they're going to present yesterday. Like she said in open court, it's going to be videos of me. Then she should have had no problem saying, it's going to be the video that you made called this. It's going to be the video you made called this. It's going to be the video you made called this, or posted on this or that. No. Videos. I got 586 videos.
Okay.
Which one?
So, Mr. Myers, at the hearing next week, if you have not been able to prepare for that hearing, we can put that hearing off. I don't have to decide it next week. So,
And
do you
Your Honor,
understand?
May I respond?
Sure.
So what's
Your Honor,
the,
so we've already been sending out the paper disclosure that has the information about all the videos that we have. We also are preparing, I believe it's going out today if it hasn't already gone out to Mr. Parvin, but we're sending him out, and now Mr. Myers will make sure he has access of all the videos that we're referencing. I am also happy to provide a
Real
list that I can
convenient
send to
to have
Mr.
in
Myers
jail.
that specifically identifies each video that we're going to be doing. So even though he produced them, we're absolutely disclosing them, which is required that we disclose those to him, and we're absolutely doing that. We just couldn't give them all, immediately because we have legal obligations to do redactions.
So,
And we'll
Mr.
just leave
Myers,
you there to
when
rot.
we come back next Thursday, if you think you haven't had a chance to prepare, we can always bump the hearing.
Yeah, because
So you don't
I've asked
have-
her 5 times
so you have
today. She said
less
she
time.
has it now. What paper?
More,
She's mailing it to
again.
my house while I'm in jail. This is a game.
Okay.
I don't suppose the
that-
court has Friday available, so I can come too. I'm just trying to pick a date when I would have more time. As advisory counsel, Thursday is a really heavy schedule for me. If the court can do Friday on the 28th, I have an open schedule that day.
Well, the reason we said it yesterday is then we also had the victim's input, and Mr. Parvin was here. I don't understand what
Yeah, I
happened
don't-
to the
Well,
date
things
since
have come
yesterday.
up, and I was withdrawn. Let's make it Mr. Myers.
She was
needs
watching
things.
live.
The question is,
Advisory counsel, right?
Except advisory counsel, he should have been preparing to be there because advisory counsel should be at all the hearings.
We were, but we didn't know that. Now I'm going to go to jail today.
Okay, hold on. So you'd rather do the 28th than the 27th?
You
that
dirty
way I
bitch.
I don't know how long, it sounds like it's gonna go longer than I expected. And the Friday, I have an open calendar where I can be here as long as it takes.
We still have 5 days notice for the victims, I believe.
I can text
Okay.
her right now.
Is she going to contact the victims right now?
Yeah,
Okay.
she's gonna reach out.
Yeah.
All right, let's wait for just a second on
I'd
that.
appreciate it. That way, if it does go 2 or 3 hours, I'm still available.
Okay.
I thought
Okay.
it'd be only a quick half an hour here.
Sounds like they'll make it work.
Okay, so we're gonna change the hearing on the state's motion to modify conditions of release from the 27th to the 28th, and that will be from 2 to 4:30. I'll have set aside for that. Okay, so, and again, Mr. Myers, if we get there and you can explain to me why you're not ready to go, then we'll
That's what
address
should
that.
happen,
And,
Bassfoot. Rachel
obviously,
should be
Ms. Stiles
sitting in
can
jail
respond to that
while
as
they
well.
decide this
And,
motion.
Your SLAPP motion is pending before me right now.
For me getting arrested or anything won't. This case can work independently from them arresting me when I walk out.
Correct.
Because you need to see that, please. While I'm here, can I stand up for a second?
Sure.
The SLAPP motion isn't really something that's, the criminal side of it isn't something that's really well defined yet. So like it's not really even in the rules of procedure. So I don't even know is it gonna be a standard 10-day? Because it's not even something they're required to respond to unless you order them to.
Correct.
So I don't know, is there a set period that you have to make your ruling?
60 days.
Before you order them whether to respond or not?
Oh, so I'll review it and I'll probably try to get it done this week. I mean, it just depends. And
say yes
if
or no.
I order them to respond, I'll do that fairly quickly.
Okay.
If I rule on it without making them respond, I'll also get that out fairly quickly. So
There's no need for them to respond. There's nothing that they can respond to. There's nothing to respond to. They got nothing. There's no no legitimate response that they can make. So, what are we doing here? He's going to finish it this week? So that includes the weekend? Listen. I want to believe the judge is honorable. You know, people are busy, whatever. But this should be the most, I don't understand, it doesn't make sense to me. This should be the most important thing, right? The allegation laid out in a 43-page motion.
And also, my understanding is you can rule on it without an evidentiary hearing, or you can, if you.
correct. I could rule on it.
I would prefer to have one if, you know what I mean?
All right.
Unless you feel, you know what I mean?
Well, I have to make that decision. I've started to look through it. It's pretty long, like what, 25 pages or something. So I haven't read the whole thing yet.
I know.
Well, it's not your fault. I'm just saying, I started to look at it, but I haven't read, because you have a long paragraph as to each count.
Right. It's only.
What are we doing here? What are we doing here? You know? He's looked at it? He's seen it? He lays out each count? He got to at least page 7. That's further than we got earlier in... Wow. Right? Alright, we gotta get through this thing. We gotta get through this so we can get back to the... SLAPP. Or we're gonna be making these videos for days.
I could do it, that's why to exceed, because it's like 15 pages for each count.
I'm not criticizing you.
79 to 80 page motion.
I'm not criticizing you. I'm just saying that it's going to take me a while to read it all. I have to decide whether to order the state to respond or not. And I know, as you said, that it's new to include criminal actions in this anti-SLAPP, but it's there, and we'll address it. Okay, and that's what happens. Maybe you'll be making some new law here.
That's what all this is about, because I'm the only one being charged for these videos. If there's 500.
Sacred, you're the idiot. Did you hear what the judge just said? Maybe you're making case law here. You fucking moron.
Videos of the same person that nobody else is being charged.
You don't get what's going on here, bro.
So what I'm gonna go here, I want you to hear this straight and on the record. I'm gonna go to jail right now, and there's gonna be more videos made in the next 24 hours about the victim than there has been made in her entire life. So I'll be sitting in jail, and there'll be 500 new videos about the victim. She's gonna get 500 new emails, 500 new memes made about her. How does that protect the victim? It doesn't. This is a charade.
Well, it may be.
You better charge every single person. And I want you to address this on the record, because you said this yesterday, and we kind of talked about it.
And Judge Ball also thinks if you clerk for a law clerk, that gives you judicial experience. So what's your point, Jay Kelly?
For a second.
Can you slow down, please? Slow down.
Slow down. I thought you said sit down. I apologize. Slow down. All right, so I would like to address this, something you said yesterday, because it's very pertinent as the matter. You're the trial judge, right? And so, you know, I don't know when I'll be able to get back to my computer to notice adjudicative fact, but you ordered me, not asked me. You ordered me.
Apologies,
to
Sacred.
remove your email from public posting, right? Because Gina's email is not, you know what I mean. And so, but in the period of time that it was up, right, you did receive emails, right? We went over that, you know, and I mean, are those people going to be charged with crimes?
Jay Kelly, Shannon Walker works for the University of Arizona Law School. At the time that she was contacted, she worked for a part called the. She was the director of special projects. Special projects worked with the courts. He was reaching out to see if there was a. The program was called Access to Justice. Lane reached out to her to see if the Access to Justice program could help him expose the corrupt prosecutor, Matt Walker, who just happens to be her spouse.
I'm saying, and so this is pertinent, and I want.
And sacred knowledge, sincerely apologize.
This on the record because the judge in this case received emails as a state of Arizona employee at his .state.gov, and nobody's going to be charged for those emails with a crime by the same agency that's charging me for a crime for other people sending emails to some, not even emails.
What do you mean? What did she do to Lane? Are you joking, bro? Okay, I know that this is probably unproductive, right? Derailing me like this.
Please leave a message and I'll call you back as soon as I have a chance. Thanks.
Hi, my name's Lane Myers, 520-771-2021. I see you're a director of special projects. Well, I'd like to ask if you could approve a special project where you help me end your husband's career for being a crooked-ass cop, prosecutor, wannabe, whatever he is, hiding these cops from prosecution. I figured the U of A, maybe Stacy could help me. Maybe I should talk to you or Stacy or maybe one of these. Because, you know, my wife also is an alumni of the College of Law and is actually has taught there. So, like, we got two sides that are about to come crashing together here. So, you can help me teach your husband how to follow the law, or I'm going to take his career. So, I figured since I'm a member of the community and my wife's an alumni of the law school, that maybe I could get access to the materials at the law school in order to fight for justice, since Stacy's all about justice. So I guess I got to call Stacy next.
Okay, so what did she do to Lane? Okay, so let's be clear. That is the one and only contact that Lane ever had with Shannon Walker. The one and only contact. Indirect contact through her voicemail. She got that voicemail, and instead of answering the next phone call and saying, please stop contacting me, instead of, which didn't come for another week in between the injunctions, but she got one voicemail and went directly to get an injunction against harassment. Well, that doesn't meet the legal standard. And in order to meet the legal standard, she had to lie. She lied 33 times in the initial injunction hearing. We dissected every single second of it. In fact, Sassy knows what's up. Don't you, Sassy? Those are the timestamps for each and every lie that she told during the injunction hearing. So what did she do to Lane? What did she do to Lane? The question is, what did Lane do to her? Did Lane lie on her 33 times in order to get an injunction? Is that what happened? Is that what happened? Huh? I'm just curious, is that what happened? No, that's not what happened, right? That's not what happened. He made some YouTube videos and she didn't have to watch them. It's that simple. She didn't have to watch them.
I sent. So in this case, sir, will you be charging me with 14 felonies for those emails you received yesterday at Gina's email? Because that's what we're dealing with in this case. I didn't send the victim any emails. Other people did. I'm going to jail right now for something other people did. So in that case, when we come back on Friday, you should have there should be a felony for each email you received, right?
So let me tell you how it works. Do you understand the separation of powers?
I do.
Okay. And do you understand who makes prosecutorial decisions? You understand that?
Who's delusional, Jay
Who
Kelly?
makes prosecutorial decisions?
I got it.
Not me.
I know. But I'm saying, so I should expect to walk out there and get charged for all those emails you got.
I don't have any idea what they're.
Well, I mean, you would have reported them to the police.
I'm not going to tell you what I've done or not done. I don't charge people.
That's what I'm saying.
I hear cases.
You're appointed by the governor, right?
I'm a judicial branch employee,
That's what I'm
not
saying.
an executive
You're not.
branch.
What I mean is, over at like Justice Court, they get elected through votes.
Hold on. We have 3 branches of government. I'm in the judicial branch.
Right.
I report to the Supreme.
Aaron Queen, you obviously didn't listen to the voicemail. We can't help you. Like, we can't help that level of dumb, bro.
Court.
I understand.
The prosecutor is publicly elected. She's an executive branch official. Okay?
Right.
She does their thing. I do my thing. Different silos.
Right.
Okay?
And what I'm saying is you as a judicial officer of the state of Arizona, also people could make a video about you on there and say, oh, I don't think he wears nice shirts, or I don't like the ruling he made in that case, right? They're not going to get charged with a felony.
Okay.
But I am.
Right. Again, we're pending. We're addressing the charges that are pending before me in this case.
That's what I'm talking about. Because I'm being charged for things other people did.
All right.
That might be defenses, but we're just trying
Yeah, we're not
I just
there
want to
yet.
make sure, because I want to tell my friends to get
The schedule, and I'll just affirm the case management conference of April 15th and the pretrial conference of May 16th, both at 9 a.m. You are ordered to be present at those hearings. If you're not present, then the court can issue a bench warrant for your arrest. Do you understand that, Mr. Myers?
you, sir.
All right. Anything else we need to address today?
No, Your Honor.
Just that the court already said that in the event that jury trial does go, I don't think it will, that we would waive my presence that on the April 15th.
Oh, you mean the pretrial, the case management conference?
Right.
And if they need to reset the hearing, we'll be fine with that. We can always work with the dates as we get closer.
Okay.
I don't
Yeah.
want to reset it now because I don't think that trial's going to go. That's
Okay.
why I'd rather keep it.
Yeah.
Why did you say that, though?
What?
Why do you say it won't go?
Because things always, a lot of times you get notification, may either get continued or settled before the actual jury trial date.
Yeah, I'm not giving up my...
I'm not talking about you.
Different case. He's got a different case. Maybe he's got a conflict on that date, but he's saying that
talking
case.
about in this case, the trial might not go.
No. I was talking about a reason why it could probably still be available on the 15th. I'm not going to make continuance unless I know for sure.
In your case?
Right.
Okay, I thought you meant in this case.
Yeah. All
'Cause
right.
I don't want to continue anything.
I know you don't. That's why.
This shit should have never happened.
With that, we're adjourned and you're excused.
All right. Guys, we really have a dilemma. I need some help. Okay, so here's the dilemma. We're on page 4 still, and if right now, here, hold on. If right now we decide that dissecting every single lie right now is a good idea, it's gonna take us, I don't even know how long to get through this anti-SLAPP, because next he talks about Judge Griffin, the dabbler, and we know that dabbler hearing is, first of all, I think it's 2 hours long. Second of all, it's packed full of lies. So if we pause the anti-SLAPP to analyze the lies, then it's legitimately, I don't think it's realistic that we'll even get through the dabbler before Sunday. I'm just being real. So what I propose, and I'm just floating this out there, I'm taking all comments. What I'm proposing is that we pause the lie counter. Maybe we get through the hearings that we were listening to, the Wayland. Yeah, it was Wyland and Wayland. Maybe we get through the Wayland ones and just identify the last of the lies before we get out of this paragraph, and then we just go to finishing the anti-SLAPP. I think that might give us all a better appreciation for for the gravity of what's happening here, and then we can come back and continue counting the lies. Believe me, I don't want to not count the lies. I want to get through this anti-SLAPP so the whole world knows, you know what I'm saying? So, you got any feedback? Cool. Nobody said anything? Yeah, his wife's an actual attorney. That's a fact. April, do you mean the sheet that Sassy provided for us and was a studious and diligent record keeper for? Thank you, Sassy. 33 lies we counted in less than 15 minutes. Alright, that's what we're going to do. Let me know if that's what you're talking about, April. We're going to go to the SLAPP, and maybe we can get through the SLAPP tonight if I can stay awake. And then we can get back to the lies, tomorrow. But I want to just pause. Yeah, okay, I'll do that right now then. Bear with me for a second. I can do that right this second. Save the drive. Move it there. Let's look at the file. Today, there it is. Now I want to be clear that these timestamps are not, they're not the timestamps of the video that you're necessarily watching. So if you go back to the last video that I published this morning, I think it's called, I don't remember. I don't remember what it's called. It's called All That Is Required for Evil to Succeed is for Good Men to Do Nothing. Lie counter. Alright, we got the lie counter in the description there. There you go. Next day, return to Superior Court. Mr. Myers removed, but order not to the versus Keshel. Myers contested the injunction. Brandon Griffin. All right, so we are still are here.
All right, so I've indicated that this was refiled due to a mistake in the process.
Thank you.
But she knows that she's not supposed to do that. That is not... I don't want to say it's unlawful, because I don't know for a fact if it is unlawful for her to do what she's doing. My own prison. Are you talking about Lane's wife? Believe me, she's not embarrassed.
I will grant the injunction against harassment.
Do you think that she doesn't know what is going on here? That she's not living this?
The court has jurisdiction over the parties and the subject matter. The plaintiff has appeared today. Defendant is not present. The court finds that multiple acts of harassment have occurred.
But they haven't discussed any of them.
Defendant is to have no contact with the plaintiff. Defendant is not to go to or near the plaintiff's residence. Defendant is not to go to or near the plaintiff's place of employment. This will need to be served.
Of course.
And it's effective for 1 year from the date of service.
Time out.
So the same terms apply. He'll be able to ask for a hearing if he wants to.
Your Honor, one question. Is the same requirement of not being allowed to post about me on social media included in this?
Let me double check. Go back.
Being allowed to post. Your Honor, one question. Is the same requirement of not being allowed to post about me on social media included in this?
45038, 45038, 45038. That's a lie. It shouldn't be included in this one because it wasn't included in the last one. You're making shit up.
Of not being allowed to post about me on social media included in this.
Let me double check. Go back.
Thank you.
Thank you very much, Special K. Please do. And or maybe it's just not postable. That's why. I don't know. My email address. lettersoffotion@gmail.com.
So I've indicated defendant shall have no contact with plaintiff through any form of social media. Defendant is prohibited from posting any messages or content regarding the plaintiff via any social media platform.
Thank you.
Alright, so she's the one. She takes his First Amendment away. No due process. Completely unlawful.
And Your Honor, one final question. When it comes to having the original documents sealed because of the information, is that something I would discuss today, or is that something I would talk to another department about?
Once it's dismissed,
My own prison, if that's true, that's sad.
I'm not sure if it can be sealed once it's dismissed.
The people I spoke to originally, they thought that might be possible. I just didn't know if I needed to ask you about it while you're here today. But if it's not something that would typically happen here, I can definitely figure it out.
So you should file a motion. You can file a motion
Okay.
with the court to seal documents and for file a motion
Okay.
with the court to seal documents and for maybe a protected address.
Okay.
Those might be possibilities.
Okay. Thank you.
Alright, here's what I'm gonna do. We gotta listen to this segment again. I might have missed something right there. But this is what I'm gonna do. Where was it? There it is. Manage access. Copy link. Channel. Sorry guys, bear with me for just a minute. Trying to do things in the moment so they don't get neglected. Alright, April. Here's what I'm gonna do. V. Save that. All right, guys. I'm gonna post that hearing, only the hearing. Anybody got a clever name? 33 lies in less than 15 minutes, comma, great work, Shannon. How about that? Does that sound good to you guys? 33 lies in less than 15 minutes. Great work, Shannon. Injunction hearing 10-9, Dawn Wyland. All right. That's live. So that's for you guys later. Or whenever. Alright.
And Your Honor, one final question. When it comes to having the original documents sealed because of the information, is that something I would discuss today, or is that something I would talk to another department about?
Once it's dismissed, I'm not sure if it can be sealed once it's dismissed.
The people I spoke to originally, they thought that might be possible. I just didn't know if I needed to ask you about it while you're here today. But if it's not something that would typically happen here, I can definitely figure it out.
Sylvia,
So
are you leaving?
File a
thank you
motion.
for
You can't
everything
file a motion
today.
Okay.
with the court
for everything.
to
Thank you.
seal documents and for maybe a protected address.
Okay.
Those might be possibilities.
Okay. Thank you. Thank you.
So I'm looking at pulling up the other one. So I'm going to quash the other one. did indicate on this hearing order that dismissed injunction is ordered sealed.
Oh, wonderful. Thank you.
Hopefully that will.
I appreciate
but
it.
I would follow up to see
I
if,
will.
if
I
that
will.
was done. Let's see. Someone can tell me if I'm not supposed to do that.
Somebody will tell me if I'm breaking the law, and I'll deal with the consequences then.
Thank you. Oh, great. Thank you very much.
All right. Thank you.
Thank you both. I hope you have a good evening.
Just talking for a second there. Lies for miles. That's what we got here. Lies for miles. All right. Mr. Myers contested the injunction, and at a hearing with Judge Brendan Griffin, Judge Griffin upheld the injunction despite that Mrs. Walker only showed one contact by Mr. Myers. This ruling also violated LaFaro, and Mr. Myers has appealed the decision to the Arizona Court of Appeals Division 2. The appeal remains pending. During the hearing, Judge Griffin clearly stated on the record that the court cannot order someone to remove videos posted on their own YouTube channel. Judge Griffin stated that the videos are First Amendment protected activity. Judge Griffin stated that the record reflect that Mr. Myers was allowed to keep videos related to Shannon Walker posted on his YouTube channel. Mr. Myers went on with his life and made a few videos about his court cases involving Shannon Walker, his appeal, and his plans to file lawsuits against Mr. and Mrs. Walker to hold them accountable for their actions of obtaining an unlawful injunction against him and prosecuting him without probable cause. Such lawsuits would seek civil remedies as set forth in the Arizona statutes and case law. Mr. Myers posted the For the Record hearings, which he paid $35 to the court to obtain. On March 12, 2025, Mr. Myers received a summons to appear on the 14 charges at issue here, which have been brought solely to deter, retaliate against, and silence Mr. Myers' constitutional rights to a free and open court, free press, and holding public employees accountable in their professional and official capacities. Mr. Myers has never contacted Mrs. Walker or published a news story about Mrs. Walker in her personal capacity. Mr. Myers' videos all concern matters of public record and are the sole and exclusive property of Freedom Productions, LLC. Legal standard. This case is a prosecution of an individual who owns a media company and the YouTube channel with nearly 15,000 subscribers. Doubled since then because of Shannon. Lane Myers owns Freedom Productions, LLC, an Arizona limited liability corporation incorporated in 2022. Lane Myers also owns the Lane Myers Channel for Nonviolent Social Change, the social media platform for which Lane Myers holds the exclusive copyright. Mr. Myers is charged in the indictment with making YouTube videos about matters of public and community interest involving employees of the state of Arizona, active litigation in the city of Tucson and Pima County courts, prosecutorial decision-making, the judicial process, and court system. At arraignment, the court ordered Mr. Myers to remove the videos that are alleged to the At arraignment, the court ordered Mr. Myers to remove the videos that are alleged as crimes as a condition of release. Mr. Myers agreed to remove the videos. However, the state has not notified Mr. Myers of which videos or a portion of the videos are subject to the condition of release. Accordingly, it is unknown to Mr. Myers exactly what acts are alleged in the indictment. Further, Mr. Myers contends, for the purposes of this motion, that in order to remove the videos, even temporarily, infringes on a lawful exercise of his First Amendment rights. These topics are all matters of public interest and concern. As evidenced by Mr. Myers' significant and growing social media following, Mr. Myers has amassed significant following and attention on social media due to his outspoken and opinionated criticism of local prosecutors and judges, as well as his successful self-representation in court. Mr. Myers has successfully argued multiple motions in local court proceedings, including a successful defense of an injunction against harassment in a matter involving nearly identical facts and allegation, and has successfully appealed the summary judgment dismissal in federal court in Michigan in the Sixth Circuit Court of Appeals 7. In that case, the Sixth Circuit Court of Appeals refused to consider Mr. Myers' First Amendment arguments on procedural grounds. The panel decision was 2-1, with the dissenting opinion finding that the majority opinion effectively discriminated against Mr. Myers due to his pro se status, and finding that the court should have considered the merits of the First Amendment claims. The majority opinion found that Mr. Myers' 14th Amendment due process claim was legally meritorious and that the district court had erred by dismissing it. The case Myers v. Wren 1:22-CV 178 in the Western District of Michigan. All of Mr. Myers' speech regarding matters of public interest and concern, including state employees, state officials, prosecutors, judges, attorneys, and courts, is constitutionally protected activity under the First Amendment. ARS 12751 provides in relevant part as follows. In A. Hold on for a second, guys. What's going on? My own prison you guys are having issues with? Order to remove. Are you supporters on crack? Order to remove. My own prison doesn't understand. He has to be ordered to remove something specific. You can't say oh, all the videos with Shannon Walker in them. No, that's not how it works. You talk about specifics. You're going to go to timeout. Nobody wants to hear it. Timeout. A. In any legal action that involves a person's lawful exercise of the right of petition, the right of speech, the freedom of press, the right to freely assemble, or the right to peaceably assemble pursuant to the United States Constitution or the Arizona Constitution, the person other than a state actor or an intervener may file a motion to dismiss, quash the action under this section. B. A person who files a motion pursuant to subsection A of this section has the burden of establishing prima facie proof that the legal action was substantially motivated by the desire to deter, retaliate against, or prevent the lawful exercise of a constitutional right. The moving person may submit evidence based on the record, a sworn affidavit, or other evidence that is submitted with a motion to dismiss or quash. A party is not required to file a response to a motion filed pursuant to subsection A of this section unless and until the court finds that the moving party has established the prima facie proof that the orders the party to file a response. The court shall grant the motion unless one of the following applies. Number 1. If the responding party is a state actor, the responding party shows that the legal action on which the motion is based is justified by clearly established law, and that the responding party did not act in order to deter, prevent, or retaliate against the moving party's exercise of constitutional rights. The state actor may satisfy the requirements of this paragraph by doing any of the following: establishing that the person who initiated the contact establishing that the person who initiated and conducted an investigation that resulted in the legal action and that made the decision to pursue legal action was unaware of the movement's lawful exercise of constitutional rights. Does anybody believe that for a second? Does anybody buy that? I don't think so. B. Establishing that the state actor has a consistent practice of pursuing similar legal actions against similarly situated persons who did not lawfully exercise constitutional rights. So, where's my lawsuit? Where's not lawsuit? Where's my injunction? Where are my criminal charges? Where are Profit's lawsuits and criminal charges? Where are Tuck's lawsuits and criminal charges? Where are Jason Zweck's charges? Where are I've seen some others. Where are they? Where are they, guys? Where are the charges? Where are the charges? C. Producing any other evidence that the court finds sufficient. C. In making its determination, the court shall conduct an evidentiary hearing or consider the pleadings and supporting the opposing affidavits stating facts on which the liability, defense, or action is based. Accordingly, the state statute requires first that Mr. Myers show prima facie evidence of retaliation against his lawful exercise of constitutional rights. The burden then shifts to the state to show that it did not initiate the prosecution in order to deter, prevent, or retaliate against Mr. Myers' lawful exercise of constitutional right. As set forth below, Mr. Myers easily meets his burden of showing prima facie evidence of retaliation against his lawful exercise of his constitutional right to free speech. Argument. Count 1. ARS 13-2921.01A1. Count 1 is legally unsupported because Mr. Myers did not commit the crime of harassment pursuant to ARS 13-2921.01A1 on October 18th, 2024. On October 18th, 2024, Mr. Myers made a U-turn behind the University of Arizona Law School. Mr. Myers was charged with a misdemeanor offense of interfering with judicial proceedings, ARS 13-2810A2, and was arrested on October 22nd, 2024 for that charge. That case was charged in Pima County Justice Court under the case number CR 240137770-MI. Mr. Myers filed the motion to dismiss with prejudice on December 31st, 2024. The state failed to respond. Judge Cornejo then dismissed the case without prejudice on January 13th, 2025. Therefore, Mr. Myers is currently already being prosecuted for the exact same set of facts in the Pima County Justice Court. The proper charge when someone is alleged to have violated an injunction against harassment is interfering with judicial proceedings, ARS 13-2810A2. The state cannot charge Mr. Myers in two different courts for the exact same facts. Excuse me. Unless you have special privileges because you work for the U of A Law School and you are married to the prosecutor. We'll get the full context there. The state cannot charge Mr. Myers in two different courts for the same set of facts unless you have special privileges because you work for the U of A Law School and you are married to the prosecutor. Then you can make up any reason you want to charge someone. Yeah, I had to let my dog in. It's going crazy. Right, Drax? Yeah, you're very good. Yes. Alright, go lay down. Furthermore, the U-turn on October 18, 2024 does not meet the definition of harassment pursuant to ARS 13-2921, and therefore the allegation of the violation of ARS 13-2921-01A1 fails. At no point in recorded human history is doing a U-turn on a public road miles away from the plaintiff considered an act of harassment pursuant to ARS 13-2921-01A1. How could someone be harassed by something they didn't even know was taking place? It's like the old adage, if the tree falls in the forest and no one is around to hear it, does it make a sound? How could Mrs. Walker be able to articulate that a U-turn she didn't know about until a few days later contacts or causes communication with another person by verbal, electronic, mechanical, telegraphic, or telephonic or written means? Mr. Myers was arrested already for the U-turn under the legal theory that being 160 feet from Mrs. Walker's workplace violated the distance restrictions of the injunction. How did the U-turn go from you were too close to the building to the U-turn contacts or causes of communication with another person by verbal, electronic, mechanical, telegraphic, telephonic, or written means? How does a car driving on a public road on the other side of town contact someone? This is clearly nothing more than an attempt to deter Mr. Myers from exercising his First Amendment rights to protest the actions of Matt and Shannon Walker, who are both state actors, on his YouTube news channel. There is no legal standard by which these facts could support a criminal charge, let alone the aggravated felony. This is First Amendment retaliation and an attempt to silence and deter Mr. Myers from criticizing Mr. and Mrs. Walker on his YouTube news channel for their performance in their official capacity as State of Arizona employees. Count 2. ARS 1329-2101A1. Count 2 is legally unsupported because a social media video would fall under electronic harassment pursuant to ARS 13-2916, not harassment pursuant to ARS 13-2921. On October 21st, 2024, Mr. Myers posted a video on his YouTube channel which he talked about his own pending injunction for harassment with Mrs. Walker in his capacity as a news reporter on his news media channel. It was all a matter of public record, and there are no gag orders in place preventing Mr. Myers or KGUN 9 or any other news media outlet from discussing it. Yeah, reach out to KGUN 9 if we haven't reached out to KGUN 9. Any news agency that'll listen, right? Any news agency that has an inbox that receives emails, send them this SLAPP motion and say, oh my God, dear Lord, have you seen what's going on in Tucson? They have gone completely insane, and this person is currently being held in jail without bond for some YouTube videos, a U-turn on a public street, some memes, and some videos that other people published, some emails that other people sent, some voicemails that other people left. Yeah, that sounds reasonable and rational that we should hold Mr. Myers responsible for all of those things. And that they're all crimes also, that they're crimes too. Merely saying the plaintiff's name when discussing a case between the parties is not a crime of harassment or a violation of the injunction for harassment. The video does not fall under any of the subsections of 132916A. The video was regarding a public employee for a legitimate purpose regarding matters of public interest and therefore is constitutionally protected speech or activity pursuant to ARS 132916C1. Furthermore, the video was not an act of harassment or done in a harassing manner, and it did not cause a communication with Shannon Walker by Mr. Myers. Shannon Walker may have voluntarily sought out and viewed the video, but Mr. Myers did not send or transmit it to her in any way. Therefore, it does not fall under any of the subsections of 13-2921A. The proper charge when someone is alleged to have violated an injunction against harassment is interfering with judicial proceedings, ARS 13-2810A2. On November 14th, Judge Griffin explicitly stated during his ruling that the IAH contested hearing that the video posted on October 21st October 21st, 2024 was allowed to remain on Mr. Myers' YouTube channel because it's First Amendment protected activity involving a public official. This charge is solely intended to retaliate against Mr. Myers for discussing matters of public record and interest in the hopes of removing the videos from the internet so that the public does not see the evidence of Shannon Walker lying in court under oath 33 times in one day. This action is clear retaliation aimed at preventing public knowledge of Mr. Myers' court proceedings. It'll be a jury of 12 because he's facing so much time. All right. Count 3 is legally unsupported because Mr. Myers did not commit the crime of harassment on January 22nd, 2025. On January 22nd, 2025, Lane Myers released the FTR hearing provided by Pima County Superior Court and discussed legal issues and arguments contained in Mr. Myers' appeal of the injunction against harassment filed in Division 2, of the Arizona Court of Appeals. The case number is 2CACV 2025-00017. Count 2 is legally unsupported because a social media video would fall under electronic harassment pursuant to ARS 132916, not harassment pursuant to 132921. On January 25th, Mr. Myers posted a video on his YouTube in which he talked about his own pending injunction for harassment with Mrs. Myers in his capacity as a news reporter on his news media channel. It was all a matter of public record, and there are no gag orders in place preventing Mr. Myers or KGUN 9 or any other news media outlet from discussing it, or like we're discussing it now. Merely saying the plaintiff's name, Shannon Walker, when discussing a case between the parties is not the crime of harassment or a violation of the injunction of harassment. The video does not fall under any of the subsections of ARS 132916A. The video was regarding a public employee for the legitimate purpose regarding matters of public interest and therefore is constitutionally protected speech or activity pursuant to ARS 132916C1. Furthermore, the video was not an act of harassment or done in a harassing manner, and it did not cause a communication with Shannon Walker by Mr. Myers. Shannon Walker may have voluntarily sought out and viewed the video, but Mr. Myers did not send or transmit it to her in any way. Therefore, it does not fall under any of the subsections of 132921A. The proper charge when someone is alleged to have violated an injunction against harassment is interfering with judicial proceedings, ARS 132810A2. This charge is solely intended to retaliate against Mr. Myers for discussing matters of public record and public interest in the hopes of removing the videos from the internet so that the public does not see the evidence of Shannon Walker lying in court under oath 33 times. This action is clear retaliation aimed at preventing the public knowledge and participation of Mr. Myers' court proceedings. Although I say 33 lies, but I mean, there's that whole Dabbler hearing, so that thing's packed full of lies, so it's gotta be, excuse me guys, I'm exhausted. It's gotta be, I lost it. What was I saying? Yeah, just the lies. She lies a lot. She lies about not lying. She's a compulsive liar. I mean, who else can tell 15... Look at me trying to extend some grace. Who else can tell 33 lies in less than 15 minutes? And then we heard a couple more lies in the next hearing. So at least 3, right, Sassy? Or Kay? It was at least 3 more lies because she was sworn under oath twice. So that was 2 right there. So we're at least up to 35, 36. That's a lot of lying. Wouldn't you say? But there's no criminal penalty for perjury. But let's hold Lane in jail without bond. Let's fill this voicemail up. Let's send him all the emails. CC me to the emails. I'll forward them to the Attorney General. Something, guys. Let's keep working on this. Count 4, ARS 13292101A1. Count 4 is legally unsupported because Mr. Myers did not commit the crime of harassment on January 24th, 2025. On January 24th, 2025, Mr. Myers posted 4 injunction hearings in 1 YouTube video. The 4 videos were all public records obtained from the Pima County Superior Court. The video did not contain any other statements or comments. Count 2 is legally unsupported because the social media video would fall under electronic harassment pursuant to ARS 132916, not harassment pursuant to ARS 132921. On January 24th, Mr. Myers posted a video on YouTube in which he talked about his own pending injunction for harassment with Mrs. Walker in his capacity as a news reporter on his news media channel. It was all a matter of public record, and there are no gag orders in place preventing Mr. Myers or KGUN 9 or any other news media outlet from discussing it. Merely saying the plaintiff's name when discussing a case between the parties is not the crime of harassment or a violation of the injunction for harassment. The video does not fall under any of the subsections of 132916A. The video was regarding a public employee for the legitimate purpose regarding matters of public interest and therefore is constitutionally protected speech or activity pursuant to ARS 132916C1. Furthermore, the video was not an act of harassment or done in a harassing manner, and it did not cause a communication with Shannon Walker by Mr. Myers. Shannon Walker may have voluntarily sought out or viewed the video, but Mr. Myers did not send or transmit it to her in any way. Therefore, it also does not fall under any of the subsections of 132921A. The proper charge when someone is alleged to have violated an injunction for an injunction against harassment is interfering with judicial proceedings, ARS 132810A2. This charge is solely intended to retaliate against Mr. Myers for discussing matters of public record and interest in the hopes of removing the videos from the internet so that the public does not see the evidence of Shannon Walker lying under oath. This action is clear retaliation aimed at preventing the public knowledge and participation of Mr. Myers' court proceedings. No, there's no threats. There's no threats at all. Count 5, ARS 13292101A1. Count 5 is legally unsupported because Mr. Myers did not commit the crime of harassment on January 27th, 2025. On January 27th, 2025, Mr. Myers posted a video discussing the appeal case listed above and the lawsuit he intends to file once the appeal has concluded. He also discussed the belief that the injunction hearings lacked legal merit. Mr. Myers posted a video on YouTube in which he talked about his own pending injunction for harassment with Mrs. Walker in his capacity. Mr. Myers posted a video on YouTube in which he talked about his own pending injunction for harassment with Mrs. Walker in his capacity as a news reporter on his news media channel. There's a lot of repeats after we get through identifying the allegation on the specific date. So, because all these charges are the same basically. Merely saying it's all a matter of public record and there are no gag orders in place preventing Mr. Myers or KGUN 9 or any other news media outlet from discussing it. Merely saying the plaintiff's name when discussing a case between the parties is not the crime of harassment or a violation of the injunction for harassment. The video does not fall under any of the subsections of 132916A. The video was regarding a public employee for the legitimate purpose regarding matters of public interest and therefore is constitutionally protected speech or activity pursuant to ARS 132916C1. Furthermore, the video was not an act of harassment or done in a harassing manner, and it did not cause a communication with Shannon Walker by Mr. Myers. Shannon Walker may have voluntarily sought out and viewed the video, but Mr. Myers did not send or transmit it to her in any way. Therefore, it does not fall under any of the subsections of 132921A. The proper charge when someone is alleged to have violated an injunction against harassment is interfering with judicial proceedings, ARS 132810A2. This charge is solely intended to retaliate against Mr. Myers for discussing matters of public record and interest in the hopes of removing the videos from the internet so that the public does not see the evidence of Shannon Walker lying in court under oath. This action is clear retaliation aimed at preventing public knowledge and participation of Mr. Myers' court proceedings. I gotta use the bathroom, guys. Yep. What do you guys want to listen to while they go and do that? How about this? We'll mix things up and we'll throw everybody off.
You have reached Shannon Walker, Director of Special Projects at the James E. Rogers College of Law. Please leave a message and I'll call you back as soon as I have a chance. Thanks.
Hey Shannon, I know you think hiding behind the website and all that's going to stop this, but it's not. It's only going to keep going, and you're just going to get yourself and the university in more and more lawsuits and more complaints, and you're just literally bringing more attention on yourself by avoiding making a comment. If you want to make a comment for the story, you make a comment and then it goes away, and then if we contact you after that, then you have standing. But this hide and lie and manipulate and go behind back channels and have your husband try this and that, it's not going to work. Unless you quit your job at the U of A, you're going to face this public scrutiny. So you can hide your number, you can do all that, it's not going to change anything. Everybody knows where you live, everybody knows where you work, nobody's trying to hurt you, Shannon. We just want information.
We're out here today to ensure our natural rights are respected by those who swore an oath to support, protect, and defend the rights of the people. The purpose of all interactions is to peacefully promote government accountability and transparency. Please like, share, and subscribe so this message can reach as many people as possible. I implore you to peacefully seek redress to any and all of your grievances. This is a public service. Yeah, intermission. It's almost, we're almost halfway through the charges, but not nearly halfway through this motion. So there is a bunch of contact information in the description. I should put my own email in there. I wonder if YouTube would hit me for putting my own Gmail in the description. But CC me to any of the emails. I'd appreciate it. That's right. Nobody's going to your kid's school. Nobody's trying to hurt you, Shannon. Fuck out of here.
I was wondering if you... Good morning, Shannon. My name is Lane Myers. I'm an independent journalist. I'm doing a story regarding a case that's taking place in Tucson. I was wondering if you'd like to put a statement on the record whether or not you had any involvement in my wife getting fired from her job. You know, I'm giving you the courtesy of... I'm willing to quote you directly, but instead you guys want to hide and play games and use the legal system and hide behind...
Sylvia had to cut out. She is a moderator. She was working all day on this, so I really appreciate some of the people behind the scenes that that take so much of their time to help. I probably don't properly convey my gratitude, but know that I'm grateful for it.
Fake injunctions that are going to get dismissed and all this kind of shit and try to violate my rights. I can come to the law school. There's nothing that can stop me by law. And so, like, you know, we can do this like the easy way, the expensive way, or like the uncomfortable way. But you're a member of the University of Arizona faculty. You're a public employee. I'm a journalist. I have the right to free press. I want to ask you, you can have the media department, whatever. If you don't want to, your actions indicate guilt. I'm giving you a chance to say, hey, I know it looks wild what's happening, but that's not true. But instead you want to run and hide, that's fine. You have that right. I'm not going to hurt you. I don't have nothing. But in a working capacity, I am going to, you know, attempt to get a quote from you. And if you don't want to give a quote, then just say you don't want to give a quote. But either way, I have the right to question you. And you can't weaponize the fake court like you and your husband, or like Stacy and your husband, all that shit. It's not going to work. You're just going to get sued. So, public employee, public scrutiny. Welcome to the real world. It's called, it's when you're an adult, you have to deal with scrutiny.
How long was that? How long was that kind of talking there? Count 6. ARS 13-29-21-01 A1. Count 6 is legally unsupported because Mr. Myers did not commit the crime of harassment on February 22nd. Actually, before I get into this, I had another document that might be helpful. Where is it? There it is. All right. Today. All right, so here is a link. There is a link to all of these counts that he's talking about in the corresponding YouTube video that is indicated with each count where applicable. Download them, make sure they're preserved, and then re-upload them. So that they're all over the all over YouTube and all over the internet. But at the very least, some of them are long, so if you can preserve them, that'd be good. All right, we'll get back to this. Get back to this motion. All right, I just started 6, right? On February 22nd, 2025, hold on, I gotta blow my nose. On February 22nd, 2025, Mr. Myers posted a video of the injunction hearings and discussed his belief that Shannon Walker committed perjury during the injunction hearing. Okay. And what did we discover today, guys? We discovered that during the one hearing on 10/9, she committed perjury 33 times. It's hard to understate that, right? The 33 lies in less than 15 minutes. The recordings of the hearings are public record. The video includes Mr. Myers doing legal research on the Westlaw legal research platform. Mr. Myers posted a video on YouTube in which he talked about his own pending injunction for harassment with Ms. Walker in his capacity as a news reporter on his news media channel. It was all a matter of public record, and there were no gag orders in place preventing Mr. Myers or KGUN 9 or any other news media outlet from discussing it. Merely saying the plaintiff's name when discussing a case between the parties is not the crime of harassment or a violation of the injunction for harassment. The video does not fall under any of the subsections of ARS 132916A. The video was regarding a public employee for the legitimate purpose regarding matters of public interest and therefore is constitutionally protected speech or activity pursuant to ARS 132916C1. Furthermore, the video was not an act of harassment or done in a harassing manner, and it did not cause a communication with Shannon Walker by Mr. Myers. Shannon Walker may have voluntarily sought out and viewed the video, but Mr. Myers did not send or transmit it to her in any way. Therefore, it does not fall under any of the subsections of 132921A. The proper charge when someone is alleged to have violated an injunction against harassment is interfering with judicial proceedings, ARS 132810A2. This charge is solely intended to retaliate against Mr. Myers for discussing matters of public record and interest in the hopes of removing the videos from the internet so the public does not see the evidence of Shannon Walker lying in court under oath. This action is clear retaliation aimed at preventing public knowledge and participation of Mr. Myers' court proceedings. Count 7. ARS 13292101A1. I was actually looking for that earlier. I don't know if it was somewhere else when I was on John Felix's channel. I was looking for the police report where they were calling Lane Shannon's ex, but I couldn't find it. But that's what we're talking about here, right? That's why this is so serious, because, you know, the jilted lover. The jilted lover. Good night, Raya. Thank you for coming in. Please send, or you said you did send an email, didn't you? I don't remember. No, you sent me cash money, bro. Appreciate that. Send an email too, though, and a voicemail. Wow, that's quite the allegation. I wonder if it's true. Nico and Sai, I'm sorry that we never got together today. You guys want to call in right now and talk? Let me know if you're interested. I'll email you my number and you can call in. We can talk about what's going on. I think I emailed, did I forward any of the case documents to you? I thought that I did, but it's been a fucking blur the last 48 hours or so. Have we started count 7? I can't believe it's gotten this far either, Lucas. This is another level. I mean, 45 years to life we're talking about. 45 years to life. He should win on an appeal unless he's in jail when his appeal brief reply is due. That could put a real, that could really hem that up. Real interesting timing, wouldn't you say? That's right, Dale. Absolutely right. Count 7 is legally unsupported because a voicemail would fall under electronic harassment pursuant to ARS 132916, not harassment pursuant to ARS 132921. The voicemail does not fall under any of the subsections of 132916A. Voicemail was a communication to a public employee for the legitimate purpose regarding matters of public interest and therefore is constitutionally protected speech or activity pursuant to ARS 132916C1. Furthermore, the voicemail was not an act of harassment or done in a harassing manner and therefore does not violate ARS 132921. And we're talking about the initial voicemail at this point. We're not seeing, I'm not, if there are honorable people in the court, they're making themselves real scarce. Real scarce. People that said they were down for justice, people that said it to me, that they were down for justice and doing the right thing, are showing their true colors. That's okay. It'll all get exposed. Mr. Myers made one phone call to Shannon Walker's work phone number on September 12th, 2024. Do we need to listen to that call again, guys? Do we? I don't think we need to listen to that call again, but we all know what's on that call, right? The call was made in Mr. Myers' capacity as an independent journalist investigating the prosecution of Mr. Myers by City Prosecutor Matt Walker, and in Mr. Myers' capacity as a self-represented defendant seeking assistance from the Director of Special Projects at the University of Arizona Law School, who at the time was Miss Walker. Mr. Myers never contacted Mrs. Walker at her personal telephone number, personal email, personal address, in any personal capacity whatsoever. The only communication that Mr. Myers directed at Mrs. Walker was in her professional capacity and involving a matter of public concern that Mr. Myers was investigating and party to. Calling a public employee on a public phone number during public hours and leaving a voicemail in the exact reason Arizona state law requires the contact information of the state of Arizona employees to be posted on the public website. The contact information for the state of Arizona judges is listed on the website, and the public is allowed to call the judge and leave a voicemail as long as it is not threatening. So, please do that. Because there's I don't know if I've been clear. I'm not sure if I've been completely clear on this topic. There's one person that can take action right now and get Lane out of jail, right? Or there's one person that can get the ball rolling so that happens very quickly, right? And that person is pinned in the top of the chat. There's a lot of other emails in the description. CC all those people to the email that you send the judge. Attach that SLAPP motion, that's also in the description. And try to find out if there are any honorable judges left. I don't know what to say. I mean, I don't know what to say. But I do know this. Help me out. Send the email, make a call a news station, call the Attorney General, people that know how to use Twitter, tweet or whatever, you know. I don't know. Yep, Judge Metcalf. Where are we at? I'm not sure if this is where I'm at or not, but we'll start here. That is no different. Yep, that is no different from any other state of Arizona employee with their contact information listed on the state website. If the public was not allowed to freely redress their grievances with public employees, then the contact information would not be listed. The state does not have a legitimate interest in suppressing the redress of grievances against it or supporting speech that is critical of it. This charge against Mr. Myers is intended to deter and scare other members of the public from participating in petition of public employees. The biggest red flag is the fact that no one else is being charged for leaving a voicemail with State of Arizona employee Shannon Walker. Only Mr. Myers is being targeted in a clearly targeted prosecution. I've left more. I think I've left more voicemails than Lane. I'm not positive, but pretty sure. Count 8, ARS 13292101A1. Count 8 is legally unsupported because social media video would fall under electronic harassment pursuant to ARS 132916, not harassment pursuant to ARS 132921. On September 24th, 2024, Mr. Myers posted a video in which he showed Shannon Walker's public webpage on the University of Arizona website. The video does not fall under any of the subsections of 132916A. The video was regarding a public employee for the legitimate purpose regarding matters of public interest and therefore is constitutionally protected speech or activity pursuant to ARS 132916C1. Furthermore, the video was not an act of harassment or done in a harassing manner, and it did not cause a communication with Shannon Walker. Shannon Walker may have voluntarily sought out and viewed the video, but Mr. Myers did not send or transmit it to her in any way. Therefore, it does not fall under any of the subsections of 132921A. On November 14, 2024, Judge Griffin stated on the record at the IAH contested hearing that the video posted on September 24th, 2024 was allowed to remain on Mr. Myers' YouTube channel because it's close. Was allowed to remain on Mr. Myers' YouTube channel because it is First Amendment protected activity involving a public official. Mr. Myers' video is covered by Rule of Professional Conduct 3.6, Trial Publicity. This charge is intended to deter and prevent Mr. Myers from showing the public exactly what was said and done in open public court in a proceeding in which he is a party. A lawyer who is a member of the Bar Association could release the same video and would not be charged with the felony. This charge is retaliation against Mr. Myers' free speech and his actions of showing the truth, the whole truth, and nothing but the truth. This is exactly why the Arizona legislature created the Anti-SLAPP law. This action is clear retaliation aimed at preventing public knowledge of Mr. Myers' court proceedings. Count 9. ARS 13292101A1. Count 9 is legally unsupported because the social media video would fall under electronic harassment pursuant to ARS 132916, not harassment pursuant to 132921. On October 2nd, 2024, Mr. Myers posted a video on YouTube regarding Pima County Attorney Samantha Walker and Mr. Myers pending court cases in Pima County Justice Court at the time. The video was not regarding or discussing Shannon Walker. Samantha Walker may have confused Samantha Walker may have been confused for Shannon Walker, the video does not fall under any of the subsections of 132916A. The video is regarding a public employee for the legitimate purpose regarding matters of public interest and therefore is constitutionally protected speech or activity pursuant to ARS 132916C1. Furthermore, the video was not an act of harassment or done in a harassing manner, and it did not cause a communication with Shannon Walker. Shannon Walker may have voluntarily sought out and viewed the video, but Mr. Myers did not send or transmit it to her in any way. The video did not discuss anything related to Shannon Walker. Therefore, it does not fall under any of the subsections of 132921A. On November 14th, 2024, Judge Brendan Griffin stated on the record of the IAH contested hearing that the video posted on October 2nd, 2024 was allowed to remain on Mr. Myers' YouTube channel because it is First Amendment protected activity involving a public official. Mr. Myers' video covered by Rule of Professional Conduct 3.6 trial publicity. This charge is intended to deter and prevent Mr. Myers from showing the public exactly what was said and done in an open public court in a proceeding in which he is a party, and a lawyer who is a member of the Bar Association could release the same video and would not be charged with a felony. This charge is retaliation against Mr. Myers' free speech and his actions of showing the truth, the whole truth, and nothing but the truth. This is exactly why the errors, I felt like I just read that. Whatever. And nothing but the truth. This is exactly why the Arizona legislature enacted the Anti-SLAPP law. This action is clear retaliation aimed at preventing public knowledge of Mr. Myers' court proceedings. Alright, we're on count 10. Oh boy. Sounds good. Sounds good, Nico and Sai. I appreciate that. And I can give you, well, I don't know if I put it in the chat or not, or not the chat, in the description, the word, the PDF that had the charges and the associated YouTube videos, but that's at least a good template. But we'll talk tomorrow. I appreciate it a lot. So, count 10. Hold on for a sec. What's going on, Dr. Scrolls? The worst followers on the planet, why? Must have missed something. Alright. Count 10. Have I started reading this? Shit. Somebody tell me if I started reading this already. I don't even know if I started reading it. Fuck. Alright, whatever. Count 10. Alright, take it easy, bro. I appreciate you coming in. Content is legally unsupported because a social media video would fall under electronic harassment pursuant to ARS 132916, not harassment pursuant to ARS 132921. On October 8th, 2024, Mr. Myers posted a video regarding City of Tucson prosecutor Matt Walker's malicious attempt at filing a Rule 11 motion against Mr. Myers. Matt Walker is Shannon Walker's husband. The video was regarding a public employee for the legitimate purpose regarding matters of public interest and therefore is constitutionally protected speech or activity pursuant to ARS 132916C1. Furthermore, the video was not an act of harassment or done in a harassing manner, and it did not cause a communication with Shannon Walker. Shannon Walker may have voluntarily sought out and viewed the video, but Mr. Myers did not send or transmit it to her in any way. The video did not discuss anything related to Shannon Walker, therefore it also does not fall under any of the subsections of 132921A. On November 14th, Judge Brendan Griffin stated on the record at the IH contested hearing that the video posted on October 8th was allowed to remain on Mr. Myers' YouTube channel because it is First Amendment protected activity following activity involving a public official. Mr. Myers' video is covered by Rule of Professional Conduct 3.6, trial publicity. This charge is intended to deter and prevent Mr. Myers from showing the public exactly what was said and done in open court in a proceeding in which he is a party. A lawyer who is a member of the Bar Association could release the same video and would not be charged with a felony. This charge is retaliation against Mr. Myers' free speech and his actions of showing the truth, the whole truth, and nothing but the truth. This is exactly why the Arizona legislature created the Anti-SLAPP law. This action is clear retaliation aimed at preventing public knowledge of Mr. Myers' court proceedings. Count 11. Count 11 is factually and legally unsupported because Mr. Myers did not commit the act of harassment or any of the subsections of 132921A in a harassing manner. On October 9th, So this was... Stop. So this was while Lane was doing this, Shannon was at court lying 33 times under oath. On October 9th, Mr. Myers went to the James E. Rogers College of Law in his capacity as an investigative journalist. Mr. Myers walked around the College of Law offices and had multiple conversations with law school employees. Mr. Myers went to the law library and used the law library. Mr. Myers never spoke or communicated in any way with Shannon Walker, who was not present at the College of Law. When Shannon Walker's co-workers offered to take Mr. Myers to Shannon's office, he declined because he did not want to intrude on Shannon Walker. Even if Shannon Walker had been present at the College of Law that day, Mr. Myers would not have gone to speak with her. All the interactions that Mr. Myers had at the College of Law employees on October 9th are video recorded. Mr. Myers behaved in a polite and non-threatening manner during all the interactions with the College of Law employees. Mr. Myers did not cause a communication with Shannon Walker on October 9th, 2024. This charge is in retaliation for Mr. Myers entering a public building during public hours and asking questions of public employees other than Mrs. Walker. Mrs. Walker was not present or near the building at the time. This charge was intended to scare the public from exercising First Amendment rights, including the freedom of press, Count 12. I don't know how much more I got, but we're on page 18. So I mean, I know for a fact we're not going to get through it, but I don't know how much past the counts we're going to get. Count 12. Did I post that a couple days ago? I don't remember. Please reach out to the judge and news stations, guys. Tell your grandparents about it and your parents. Give them this anti-SLAPP and tell them to read it. Count 12. Count 12 is legally unsupported because a voicemail would fall under electronic harassment pursuant to ARS 132916, not harassment pursuant to 132921. A voicemail does not fall under the subsections of 132916A. The voicemail was a communication to a public employee for the legitimate purpose regarding matters of public interest and therefore is constitutionally protected speech or activity pursuant to ARS 132916C1. Furthermore, the voicemail was not an act of harassment or done in a harassing manner and therefore does not violate 132921. Mr. Myers simply called and asked Shannon if she had anything to do with Mr. Myers' wife being fired from her position as a judicial law clerk. Someone, either Shannon Walker or Stacy Jane, called Judge Zips and fabricated a bunch of lies and defamed Mr. Myers, leading to his wife being terminated. Mr. Myers was exonerated of all charges, just like he will be here. Mr. Myers then reached out to Shannon Walker in her official capacity and Mr. Myers in his journalist capacity, asking if she would like to make a statement for the record and put this all behind us once and for all. She chose the worst possible idea and is attempting to criminalize First Amendment protected activity. Calling a public employee on a public phone number during public hours and leaving a voicemail is the exact reason the state of Arizona requires the contact information of the state of Arizona employees to be posted on their public website. The contact information for the state of Arizona judges is listed on the website, and the public is allowed to call and encouraged to call the judge and leave a voicemail as long as it's not threatening. And please, for the love of all that is good and holy, do that. That is no different from any other state of Arizona employee with their contact information listed on the state website. If the public was not allowed to freely redress their grievances with the public employees, then the contact information would not be listed. The state does not have a legitimate interest in suppressing the redress of grievances against it or suppressing speech that is critical of it. The charge against Mr. Myers is intended to deter or scare other members of the public from contacting public employees. The biggest red flag is the fact that no one else is being charged for leaving a voicemail with state of Arizona employee Shannon Walker. Only Mr. Myers is being targeted in a clearly targeted prosecution. Count 12. Count 13. Man 13. Yeah. Count 13 is legally unsupported because a voicemail would fall under electronic harassment. Alright, I think that's the one that somebody had left a comment saying that he copy and pasted the same facts. That looks to be accurate. Count 14. ARS 1329-2301A2. Count 14 is legally unsupported because Mr. Myers did not engage in a course of conduct directed towards Shannon Walker. Mr. Myers posted YouTube videos regarding an injunction against harassment, his legal arguments and analysis in the case, and the appeal of that case. None of those videos were directed towards Shannon Walker. Shannon Walker may have voluntarily sought out and viewed Mr. Myers' videos, but Mr. Myers has never sent or transmitted any video to Shannon Walker in any way. Furthermore, Mr. Myers never caused a communication with Shannon Walker through or in any YouTube video, because no single act that Mr. Myers engaged in rises to the level of criminal harassment. The combination of acts The combination of acts does not rise to the level of harassment. Further, none of Mr. Myers' videos discussing his cases include threats of harm directed at Mrs. Walker or anyone else. Mr. Myers has not contacted Mrs. Walker since October 16th, when leaving a voicemail before the IAH was served on October 18th. Calling a public employee on a public phone number during public hours and leaving a voicemail is the exact reason the Arizona law requires the contact information of the state of Arizona employees to be posted on the public website. The contact information for the state of Arizona judges is listed on the website, and the public is allowed to call the judge and leave a voicemail as long as it is not threatening. Please do that, by the way. That is no different than any other state of Arizona. That is no different from any other state of Arizona with their contact information listed on the website, on the state website. If the public was not allowed to freely redress their grievances with the public employees, then the contact information would not be listed. The state does not have the legitimate interest in suppressing the redress of grievances against or suppressing speech that is critical of it. This charge against Mr. Myers is intended to deter and scare other members of the public from contacting public employees. The biggest red flag is that no one else is being charged for leaving a voicemail with the state of Arizona employee Shana Walker. Only Mr. Myers is being targeted in a clearly targeted prosecution. All of the videos that Mr. Myers has posted on his YouTube discussing Shana Walker or the injunction against harassment are constitutionally protected speech. For that reason, Judge Griffin, when granting the injunction against harassment, explicitly found that he could not order Mr. Myers to remove any of the videos and that all of the videos were allowed to remain posted on YouTube. Therefore, Mr. Myers is now being charged with crimes for videos that a judge has already found did not violate the injunction against harassment and which a judge has already ordered to remain on YouTube. Mr. Myers' video is covered by Rule of Professional Conduct 3.6 trial publicity. This charge is intended to deter or prevent Mr. Myers from showing the public exactly what was said and done in open court, in open public court, in a proceeding for which he was a party. A lawyer who is a member of the Bar Association could release the same video and would not be charged with a felony. This charge is retaliation against Mr. Myers' free speech and his actions showing the truth, the whole truth, and nothing but the truth. This is exactly why the Arizona legislature enacted the Anti-SLAPP law. This action is clear retaliation aimed at preventing public knowledge of Mr. Myers' court proceedings. I think that best to leave off there, or we're going to get into something quite long. No, I think habeas is on the table right now. But you made a good point. He's got to file on his own behalf at this point, right? But he mentioned that in our phone call today. Yeah, he has standby counsel. William, Mr. Parvin is standby counsel. Now he was appointed counsel in the new charges. But they'll all be consolidated at some point, and Lane will be the guy on it. But that's not what's most important right now. The habeas is a realistic option, but somebody can get him out right now. Somebody can take action right now with this on this anti-SLAPP, and that's the judge, Douglas Metcalf, the Honorable Douglas Metcalf. The Honorable Douglas Metcalf. I don't know. I'll believe that. So if then Parvin could file the habeas, right? If Cat can do it, he could do it. I appreciate that, Torque. Just trying to, keep things in perspective as, this obviously wouldn't ideally be what I'm doing, right? But that's what I have to keep. Perspective is important, right? I'm not sitting in a jail cell. I'm not sitting in a jail cell, so, Lucas, I don't know. I don't know for a fact if he filed anything before he was taken. He did discuss that with me, that these all this stuff here would be pushing that, and obviously it will be now. But I think it matters if something was filed, if he actually filed something. Otherwise, the court, Kent would be looking for anything, and maybe it would get ironed out eventually. But you could see a warrant being issued. It's not. I don't think it's a stretch to. To jump there mentally, you know what I mean? I'm going to bed too, guys. I really appreciate you guys coming in. We'll get the last 20 pages of this done tomorrow, hopefully. Please send some emails, CC me to them. Same with the voicemails. Yeah. No doubt about it. Dirty tricks. Good night, Sassy. Thank you for all your help. Everybody, thank you for everybody that's helped. I really appreciate all the help that you've given. Everybody that's sent an email or made a phone call or tried to get more public awareness on this, I really help. Anybody that's made a video and shared it, I really appreciate it. Thank you so much. Night, Lucas. Thank you. Everybody have a good night. We'll get up and start going at it in the morning.